My Lord, the Chief Justice had remarked that the 62 judgment of Sayyidna was, my Lord, between the Sayyidna and the government. And probably, my Lord, members of the community were not there, is your Lordship's remark, my Lord. This could be like Order 1, Rule 8, etc. So I just wanted to say, my Lord, in that case, the Sayyidna represented, my Lord, the community. And what is most important is, my Lord, I put it in the note, 5 pages of the judgment are devoted to an intervener who, my Lord, took the same stand as the respondents are now taking. That he has no power of excommunication, he is, my Lord, doing this, that, and the other. All that, my Lord, is cited there, number 1. Number 2, my Lord, I am, my Lord, an intervener in Sabarimala. I am also an intervener in the 1986 writ petition, which, my Lord, is a challenge to the judgment. From Mirajkar downwards, my Lord, and the Chief Justice's judgment in Satish Misra has taken the view that you can't have a writ, my Lord, against a judgment of the court. I have also now put it here, my Lord, curiously, that writ is by a proclaimed so-called body, my Lord, a board. It was not registered, it had no members. It had one protagonist called Asghar Ali, engineer. So, my Lord, he acted for his own board, he has no followers, and he was petitioner too in that 86 writ. He died, it was taken over by another person, I have named, he has also died. So, really speaking, my Lord, the writ has abated. There is nobody in the writ now. There is nobody in the writ, my Lord, and therefore there is no real point of, my Lord, looking at that writ, etc., etc. And finally, my Lord, as the Lordship says, my Lord, call has already told you. I just wanted to tell you, my Lord, that judgment of Sayyadna is, my Lord, a very strong bench and a very strong bar. If your Lordship sees the names, very strong bench, and the bar was represented by K. Munshi, who was a member of the Constitutional Assembly, Attorney General, Solicitor General Mr. Sanyal, and my Lord Daftari. So, my Lord, it was a galaxy of lawyers, my Lord, who were there. The bench was also strong, and the intervener, the 5 pages are devoted, my Lord, from pages 301 to 306 of the report to the intervener, my Lord, who was represented by a well-known lawyer, my Lord, of the Supreme Court called I.N. Shroff. He started Shroff and Company, my Lord, originally, as he passed away, my Lord, early. That's, my Lord, a part of the judgment. So all this I have put in, my Lord, here, and that's all I want to say. So just one more thing. Kindly note, my Lord, that writ, my Lord, of 86 is now tagged here by Justice Oak's order of 2023, which is, my Lord, 5 judges. He has tagged this writ only for 2 issues, my Lord. Issues 3 and 4.
Interplay.
Which is, my Lord,
Interplay.
no, which is, my Lord, whether 26 is subject to other parts of the Constitution. And the next 4 is constitutional morality, because that wasn't there in 86, my Lord, when they read. So it is referred only for these 2 issues, 3 and 4. That is why, my Lord, we are here. We are not on facts. Call has already told you, and I put it here. The last 75 years, my Lord, there has been no excommunication. And the last known judgment of excommunication, the Privy Council of the 30s or 40s, where they read natural justice, etc. into it. It's not, my Lord, some diabolical, my Lord, want that he has, I will do this, I will do that. Not happened at all in the last 75 years. That's the position. I am very grateful.
Thank you.
And to my friend, my Lord, for allowing.
Yes, Mr. President.
May it please your lordships. My Lord, I have a brief note, and I plan, my Lord, to answer some of the questions, but more importantly, rejoin to the various points raised. My Lord, in para 3, if your lordship takes my note, I've just summed up very prettily. My Lord, there were 4 submissions. The first is that the judgment of the High Court of Gujarat is erroneous. My Lord, it dismissed the petitions. It relegated the petitioner to a civil suit on the ground that the matters required evidence. My Lord, the majority said that if she is still continuing her faith as a Parsi and has abstained from carrying on Hindu religious rites, it's a matter of evidence, and that should be established before a court for a declaration. The minority judge said that if this is a custom which is based upon religion, namely the exclusion from the fire temple, as well as the Tower of Silence, it needs to be established by evidence. So unanimously, my lord, all the three judges relegated the petitioner by way of a suit. That's, my lord, the summum bonum. But, my lord, I have only given the facts only for the sake of orderly refutation. I sincerely urge, my lord, that we don't have to go into the facts of these cases. I want to deal, my lord, with the more substantive points which have been argued. And, my lord, I see that there are 3 points which need to be dealt with. The first is, my lord, is the right located under 25(1) of the Constitution, or is 26 capable of an independent, fulfilling existence? This is, my lord, somewhat important, and it is critical. The second, my lord, is whether the principle, what I call, my lord, is plural grounding. My learned friend, Mr. Dhawan, has referred to it as assimilative interpretation of reading 14, 19, 21 together. Whether that principles of all the articles being read together in respect of 14, 19, and 21 would a fortiori apply to the landscape of these rights? That is a very critical question. And, my lord, I'm going to persuade your lordships that it is otherwise. So, my lord, this is the second point. The third one, my lord, is this question about religion and religious denomination. And, my lord, I maintain that religion in Article 25 means established doctrine of faith as is understood in common parlance like Hinduism, Islam, Sikhism, Jainism. That is religion, religion per se. Denomination, my lord, are those who belong to that faith. Those, my lord, who are Hindus, who belong to Hinduism, come together, establish an organization. That, my lord, is a denomination. So, my lord, the suggestion that there is an attempt to extrapolate the expression religious denomination to the entirety of religion as if they are co-equivalent, that is not entirely an accurate submission. The 2 words have different meanings, and I'll presently, my lord, demonstrate that. Now, my lord, I also wish to point out that in our Constitution, my lord, it is a misconception that we have something called hierarchy of rights. It is a misconception. All fundamental rights, my lord, are fundamental rights. They are entitled to equal protection. They may sometimes collide with each other, but then we have, my lord, certain useful tests to keep in mind while examining those questions. The reason why I say this, my lord, is the principle of whether you call it single proportionality, or you call it dual proportionality, or you call it fourfold proportionality, based on, my lord, a judgment in England rendered in completely different circumstances. My lord, those are principles in relation to judging whether a right is breached and whether the measure taken is proportionate or is disproportionate to the right enjoyed by a person. My lord, they have, and I admire Indira Jaisingh for her very intellectual, authentic position which she took yesterday, when she said that this fourfold test has nothing to do when we are interpreting 2 articles of the Constitution. Can your lordships imagine which part of that fourfold are you going to apply in 25(1)? Which part of that fourfold? Which part of that fourfold are we going to employ, my lord, in 26? It is incapable of application. And therefore, my lord, the question which your lordships have to deal with is that is Article 25 and 26, they may be interconnected, there may be some overlap, but, my lord, they are capable of operating in distinct spheres. If they operate in distinct spheres, I can persuade your lordships that there would be no tension between the 2 articles at all. My lord, if there is no tension, there is no conflict. If there is no conflict, even the question of harmonization may not arise. But, my lord, harmonization is a sound rule when you find that there could be a mild tension between two competing rights, but the principle of harmonization is that both rights are given equal measure of respect so that both survive. The principle of harmonization is not a principle of precedence or eclipse. That's one part. Lastly, I want to deal with a point which Honorable Justice Varale mentioned in one of the hearings. It was a very valid point about rationality. And that question, my lord, has stayed with me throughout the hearing. My lord, the submission which I want to urge for your lordship's consideration is the scope and the length of judicial review for 25 and 26 is not the same scope of judicial review under 14. In other words, an irrational factor which borders on extraneity or which borders on extreme irrelevance. My Lord Justice Sundaresh mentioned it the other day. That is relevant for judicial review vis-a-vis 14. But in the scope of 25 and 26, my lord, you may employ rationality for the purpose of logic of inquiry and determination in adjudication, but the tests of rationality are not those of 14. This is the, my lord, I wanted to respond to that. So this is, my lord, the area which I seek to cover. My lord, may I straightaway invite your lordship's attention to the reasons why I say this. Please come to page 5 of my submission. Yeah. Exactly. Thank you. My lord, I'm grateful to my learned friend, the Solicitor General, my lord, in more ways than one. My lord, Article 14 is the very antithesis of arbitrariness. That concept of arbitrariness or irrationality is quite distinct, shall we say, from the area of personal freedom under 25(1). Now, my lord, how do I distinguish 25(1) and 26? 25(1), my lord, is a wide, vast expanse of individual freedom. It's so wide, it's so vast, because, my lord, there are many stages of belief. There can be stages of disbelief. There can be stages of partial belief. There can be stages of withdrawal from belief. All these, my lord, are a part of the journey which you undertake under 25(1). Simultaneously, my lord, you could move from one teacher to another, to another, to another. It is not that, my lord, the universe of religion is exhausted by any one particular doctrine. You have any number of, shall we say, permutations and combinations on the religious tenets, and more importantly, on what could be the outcome in terms of interpersonal experiences. All this, my lord, is protected under 25(1). This entire width is protected under 25(1). And, my lord, there we have to treat conscience as somewhat independent even of religion. Because conscience, my lord, is a faculty of final, shall we say, discernment. But it need not necessarily be religious discernment. It can be moral discernment. Moral discernment would imply conscience. Religious discernment, my lord, is a slightly different subject. That is proper freedom of religion. And, my lord, here, that judgment, that is the judgment which my learned friend Indira Jaising referred to, the judgment in the 80s of whether a person who was a Shudra could become a sannyasi. That judgment, my lord, is a significant judgment because it tells you about the movements within Hindu society itself, why people took recourse to an ascetic way of life as a reaction to the practices in relation to exclusion on account of caste. And that, my lord, is a very significant judgment because there it said that a particular order, which strictly, my lord, did not belong to the Shankara, the Dashnami order, but still emulated some of the traits and aspects of that order, was entitled to follow the same principles of succession to Mahanship. So, my lord, the question is, you do what is called a Viraja Homa when you actually renounce the world. And they said that in that case it was done, and therefore, my lord, therefore he was entitled to succeed. But it is, my lord, a good historical account of how, my lord, movements happen within religion. My lord, in 25.1, why is it that the collective is not yet there? This is the question. Everybody said 25.1 is the repository of the individual, 25.1 is also a repository of the collective, and 26 is actually no more than an elongation of 25. And if 25 is subject to, well, other provisions of part 3, then why shouldn't 26 be subject to part 3? Well, that is the argument. Now, my lord, if 25.1, and my lord, it's very significant that there are 3 principles your lordships will keep in mind. One is an interpretation by which the fullness of the right is upheld is an interpretation which you would prefer to an interpretation which attenuates or diminishes the content of the right. My lord, this is the first point. The second is, my lord, if the words of the Constitution are clear, then, my lord, there is no scope for applying the theory of implied limitations when the intention to express limitations is manifest in the text of the article. This is, my lord, the second point. And there is a third point. And the third point, my lord, is the nature of individual freedom under 25.1 is not, my lord, the same as a denominational freedom under 26. The individual, my lord, can be religious one morning. He can be less than religious the next morning. He can actually meditate in whatever way he is taught or he likes. He can read, my lord, any kind of literature to inform his mind. And, my lord, we are very blessed to have varied quantity of literature written by so many scholars and, my lord, people who are experienced in the field. My lord, that's a wide panoply of experience. But once you are a denomination, you subscribe to a fundamental position of faith. It might be a doctrine which is just universal. Well, as my Lord Justice, the Chief Justice said, if 10 people in a village, my Lord, came together, designated one bottom of a tree and lit a lamp, they could well constitute a denomination, depending upon their faith. Therefore, it is when you are a member of the denomination, you tell yourself and you tell other members that we follow certain tenets. Now, my Lord, naturally, there the expression establishing and maintaining institutions, my Lord, is not simply in the context of a brick and a mortar or a temple or a church or a mosque. It is more. It is that which goes inside that institution, which is maintained under 26. That is the exposition of the faith. My Lord, these articles 28 to 29 use 6-7 words. They use the word religion. They use the word religious practice. They use the word matters and affairs of religion. They also use the word religious instruction. They also use a fifth expression, religious worship. All these, my Lord, would be within the purview of a denomination. A denomination may be able to teach you the creed of the faith. It may establish certain special tenets, like, my Lord, in case of, let us say, Vaishnava Sampradaya, any Sampradaya. So sorry.
Your submission that the individual right vis-a-vis the denominational right cannot be treated on par we have some difficulty because when both are tracing into 25(1), to the extent when you say, when an individual questions the collective wisdom of belief and practice, there what you are saying might appeal to us.
Yes,
Because 25(1), for example, individual right to practice and profess in pursuant to conscience, it is as good as that of the collective right.
no, Milord, I'm
But
great.
only its logic will apply, the reasoning might apply when individual tries to interfere with the larger right of the right, but there we may be right.
My lord, may I just explain? I'm very grateful, my lord. I'm so grateful your lordships put it to me. My lord, when it says that the individual has freedom of conscience and can freely practice the right to religion, practice, profess, propagate. My lord, an individual can also profess and propagate. An individual by himself can profess and can propagate. He can write, he can speak about it. My lord, we have any number of examples of individuals who have actually expounded on religion. It's perfectly legitimate under 25(1). When, my lord, an individual becomes a member of a denomination, I'm again bowing down to your lordships to say that election of becoming a member of a denomination is also one under 25(1). I'm making it clear. But the moment you become, my lord, a member of a denomination, then you have to trace your rights in terms of the membership of that denomination. Now, herein ties, my lord, an observation from my Lord Justice Bakchi, who said, if suppose he is a member of the denomination, but he feels that the denomination is at cross purposes with the true tenets of that particular denomination, is he without a remedy? The answer is, my lord, no. He is with a remedy. He has a civil remedy available to him to actually pursue the denomination. And if it is a legal injury, say a right, my lord, of his which has been injured, which your lordships will hear that shortly, which could even be a constitutional tort, it is something which can be examined in a suit. If it is one member of a denomination versus the rest of the denomination. The reason why I'm saying this, my lord, is denominations are also an important part of the soul of religious freedom. Individuals by themselves may not be able to establish institutions which need continuity, which need tradition, which need consistency. That, my lord, is really under 26. So, my lord, this word manage has been read slightly out of context. If your lordships read manage to mean to manage religiously what is within the domain of the affairs of that religion or denomination, it requires, my lord, an accurate meaning. And when you use the word manage instead of using the word control, it also enables internal discussions, rarifications, modifications by consent, even within the denomination. So the word manage, my lord, is a very wide, it is a dexterous use of language. And that is why, my lord, the words are affairs of religion. So those affairs include religious instruction, they include habits of worship, they include religious practice, they include, my lord, all the shades of teaching or propagation.
Wide connotation.
Yes,
Affairs is a very wide connotation.
very wide. So, my lord, if you view it this
The
way,
denomination, it is a right or a freedom of the denomination as such.
exactly,
As
my lord,
opposed to an individual as.
that's right. And
The
that,
denomination is recognized as in being independent of an individual.
exactly, my lord, that is
So-
why it is a freedom specifically conferred to a denomination. But what is most significant, my lord, is in line with the principle of equality. In 25(1), the opening words in 26 are every religious denomination. All religious denominations, my lord, have equality have freedom, and they can propagate their faith. This, I think, my lord, if you view it through this way, there is really speaking no conflict.
That is the way in which religion can be preserved in this country
I'm grateful, my lord.
under 26B.
Now, my lord, I come to a second point, which is, my lord, it is not a really well-founded suggestion that power is being conferred on denomination, or that they would act pejoratively to cause detriment to individual rights. Well, these assumptions, to start with, they actually floor the discourse, because we can't start with that assumption at all. But, my lord, your lordships can always urge that when denominations exercise their freedom, they will do so in a reasonable, responsible manner, which will behoove wisdom of that denomination. My lord, it is wisdom. Finally, wise counsel must prevail in denominations. The reason why some denominations, my lord, have sustained themselves over time is only because of the leadership, the nature of penance, the nature of teaching, the purity of standards, and it is capable of transmission. And that is something, my lord, which is within the domain of denomination. However, my lord, we come to deal with 2 points here before I come to that Article 14, 19, and 21, and subject to. These are the points. My lord, on the question of judicial review, my lord, since this is such a precious fundamental right under 25(1) and under 26, my lord, please never divest yourselves of that powers of judicial review, because this is one of the most sacred freedoms under the Constitution. Please.
Just now you're putting your submission that it is only hope then that a better sense will prevail over a denomination. It will not be possible in reality always. In that situation, the next resubmission was, then in that situation, the intervention of the court would be needed.
My lord, I cannot say that it.
Because if
Yes.
we take in reality, it will not be always that in all the times, better sense will prevail. Sometimes it is possible that somebody.
My lord, if I may say so, very theoretically and as a matter of realism, I certainly cannot rule out, my lord, the possibility that your lordships may be called upon in a given case to examine if it is, my lord, shall we say, a religious practice being practiced by a denomination which is completely abhorrent, my lord, shall we say, to fundamental human values of existence.
Therefore, the only thing that there can't be always a hands-off approach.
No, my lord, I'm requesting your lordships to, my lord, please rest your hands, but make them always available for seekers of justice in appropriate cases. Of course, whether, my lord, the matter should be relegated to an evidentiary process in a suit or a scheme under Section 92, my lord, these are all matters which control the exercise of your discretion. But this, my lord, must be available to you. The second point, my lord, is who has the last word? And here I want to draw a line, my lord, between the faith of the believer and the legal adjudication of a right. In the faith of a believer, I completely agree with my Lord Justice Sundaresh that it is subjective. Courts cannot judicially review it. And it is not, my Lord, it's not a judicial function to review consciences, shall we put it. It is, there's only one person above who reviews it. It will be very difficult for us to really review acts relating to conscience. In relation to religion and faith, the quantum of faith, the type of faith, again, my lord, subjective, not open to judicial review. However, if suppose a person were to assert,
Mr. Subramanian,
I'm so sorry.
there is a difference between judicial review and judicial determination. Whether you have a faith or not is a state of mind. And courts from time immemorial And if you see the word fact in the Evidence Act, a state of mind like honestly, dishonestly, have always been a subject of judicial determination. So what is a faith of a denomination is definitely justiciable to that extent, but not on a merit or value judgment, as you are saying, in review.
My Lord, I cede the point that judicial determination as a fact is entirely permissible.
A state of mind.
Yes, yes.
State of
including-
mind
Because
is
even belief.
definitely something which is within the court's domain to decide.
My Lord, I entirely bow down when in fact, my Lord, it is through an evidentiary process. At that time, the basic beliefs are set out for the purpose of enabling the court to be apprised of what exactly is the injury which is being complained of. So for that purpose, my Lord, certainly courts have jurisdiction. What I meant is, extra further, shall we say, my Lord, beyond adjudication or determining a state of mind as a fact, further value judgments, my Lord, are outside the purview of this. But now, my Lord, I come to the next point, which is it simply hands-off in relation to matters of religion, or can you also seek assistance in cases? This, my Lord, is important because, I'm sorry, Lord.
Yes.
My Lord, I wanted to urge for your Lordship's consideration. You may need assistance because, my Lord, as I said, all temples in this country, or my Lord, all places of worship do not follow a uniform pattern. So, my Lord, what is relevant for an archaka in place A may not be relevant for a person in state B, may be an adjoining state, but it can happen in reality. Therefore, I'm saying, my Lord, with respect, that keeping this in mind, there may be occasions when your lordships would like at least some prima facie case in relation to the assertion of a religious right. But as my Lord the Chief Justice very perspicaciously observed yesterday, that once that initial burden is discharged and a prima facie case is made out, then it is up to the person who is either invading the right by way of an executive measure or by way of a legislative intervention, that they would have to justify how is that justiciable, how is that justified. So, my Lord, this is one important aspect. What your Lordship said is that if there are matters of detail in relation to a religious practice, there your Lordships would defer. And my Lord, I use that word defer with a qualification: when called, when, my Lord, suitable, when appropriate, you would defer. So, my Lord, whenever it is appropriate, you would defer. You would defer to the wisdom of the denomination about the way in which, my Lord, the various traditions and ceremonies and forms of worship and instruction are given. So, my Lord, this is one important aspect.
It is usually when there is an encroachment or an invasion into that, the question would arise.
That is when a question would in fact arise.
Yes.
Now, my Lord, I deal with two more points. One is Maneka, because, my Lord, there, with great, profound respect to my learned friend, the solicitor, my Lord, I hold him in the highest esteem. My reflection, my Lord, is that the judgments in relation to the conjunction of fundamental rights, like 14, 19, and 21, in Cooper, Maneka Gandhi, Minerva Mills, Coelho, my Lord, they do not operate in this sphere. If your Lordships read the Constitution, even in respect of fundamental rights, as dealing with different spheres, then, my Lord, we would get a correct answer. Because in the very nature of things, my Lord, the right to religion under 25(1) is really, my Lord, in some sense, contrarian. It can be contrarian to the principle of reason in 14, because it's an act of transcendentalism when you really seek to commune with the deities or with your inner self. Well, these are different dimensions. They are not dimensions which can be tested by secular touchstones or secular yardsticks like Articles 14 and 19. Well, this is a little important. And I'll explain why, my lord, 25 and 26 have the requisite protections within themselves. 25 and 26, my lord, are unique provisions. 25, when it uses the word subject to the other provisions of this part, my lord, it uses them with a conscious purpose. It is not that it is bereft of purpose. It would be incorrect to read it as bereft of purpose. But what is that purpose? The first is, my lord, other provisions. My lord, other means it excludes 25. But that right under 25 is subject to other provisions of this part. The other provisions of this part can be divided into three categories, my lord. Three categories. The first are the rights which follow 25, namely 26, 27, and 28. Because, my lord, even they protect individual freedom. They protect against intrusive religious instruction. But they also protect a donor, a man who created an endowment. And one of the conditions of his endowment was that there should be religious instruction. They said religious instruction can be insisted in such an institution. So, my lord, your lordship sees Article 28, 27, they balance both the freedom of the individual and they also give effect to, my lord, the purposes of endowment if it is religious instruction. So, my lord, it is completely even and it is balanced. So, my lord, one set of rights to which Article 25 is subject are the rights in 26, 27, and 28. This is one part.
Because they are manifestations of
The right to religion.
under 25(1).
That's right.
And they have to be given their full meaning.
Yes.
Scope.
And, my lord, that is why you find these words: worship, instruction, religious worship, religious instruction, matters of religion, religious practice. My lord, all of them are comprehended within religion. Whether it is under 25(1), which a man does in his home, or it is, my lord, someone in a denomination who does it in a denominational setting. So, my lord, I submit with respect that it is clear individuals have a right of freedom, denominations have a right of freedom. And that brings me, my lord, to the next question. I said there are three sets of articles in
Mr.
part three.
Subramaniam, by your logic, 29, 30 would also come into.
They would, my lord.
Yes.
In a manner of speaking, if you have to
With
extend,
regard to
Yes,
minority
yes.
institutions, because the word equally now
Equally.
will stand
in
with a balance or a handicap in favor of the.
favor of the institution. And, my lord, I submit that if we read these articles together, you get a picture that the landscape of this is quite different from, shall we say, positions of vertical interplay. My lord, I really think vertical and horizontal is an oversimplification. Shall we say, in matters where you enforce rights against the state, or in areas where the state guarantees you fundamental freedoms, this, my lord, is a different set of rights where you enjoy your freedom of religion and you also enjoy the status as a minority.
Yes.
So, my lord, really speaking,
So other thing of subject to other provisions.
Yes.
In all probability.
Yes.
Would also read in the
Yes.
reasonable restrictions of 19.
now, my lord, let's look at that. May I, my lord, your lordship is coming very close to the, shall I say, to the end of it, but I'm taking your lordships through a slightly different route, if I may. But I have noted, my lord, there is some element to be observed in this because,
Although it's a special fundamental right of religion and conscience in 25(1) and a right of a denomination of 26, they seem to be subspecies of 19(1)A and 19(1)C.
now, my lord, let's look at that. I'm very grateful. I'm very grateful. If suppose, my lord, we did not have 25 and 26, there could have been a question that whether 19(1)A itself comprehended, because freedom of expression can also mean freedom of expression through your conscience, It can also mean freedom of association could as well.
We have done some degree of reverse driving in 19(1)(a) by saying right to information is inbuilt in right of expression. Now, if right of expression includes information, then it is definitely including conscience.
My lord,
Without a conscience, a person would not
my lord,
be able to.
that is why, my lord, this word conscience, if I may say so, can apply not only in relation to matters of religion under 25, it may apply whenever you are having any interaction, my lord, any transaction with the world or with in any form, there may be an element of conscience. That goes without saying.
You
In
may,
administrative law, it is very important.
In
Conscience.
my lord, that is why, my lord, I have some difficulty with the formulations, the three formulations of Honorable the Chief Justice Chandrachud in that electoral bonds case. The first, he believes that there could be a hierarchy of rights. Second, he actually says that 25 tells you that it is subject to Article 19, it is subject to Part 3. Because it is subject to Part 3, it is inferior to the others. My lord, there's a suggestion in the judgment. It's not correct. But my lord, what I am concerned is, when you are wanting to interpret articles of the Constitution, you don't interpret the articles with reference to tools of judicial review which are in the context of assessing effect of, my lord, executive action or legislative action. You take the articles themselves and you take the articles as plenary if they are rights. And if they are rights, now the question which my Lord Justice Bagchi has put to me is, aren't religious freedoms or 25 a species, and my lord, I take that word seriously, a species of the general freedoms in 19.
No.
My lord, I submit with respect.
Still to do with that.
My lord, my respectful submission is that there is a distinction. The distinction is, my lord, I'll tell your lordships the distinction. The distinction is this freedom under 25 is a subjective freedom. It is ensured by the state. It is also, my lord, laterally available. But, my lord, laterally, you assure the other citizens of their fundamental rights. Laterally, you assure other citizens of, my lord, respect for their rights. So how do you, my lord, practice equality, tolerance, coexistence of all religions? Unless you have these subject to other rights in Part 3, because there are other people. The other people may not be exercising 25(1) right at that time, or they may be exercising 25(1) right, but you need to be conscious of their freedoms, that they have fundamental freedoms. They must be respected.
Equal entitlement.
Equal entitlement, my lord, equal entitlement of all religions to be manifested in real action is the reason why you have subject to other provisions in Part 3.
Therefore, a need for a separate article.
Now, my lord, I'm now coming to it because your lordships will find there are 3 articles which are prescriptions. They are prohibitions. That is, my lord, 17, 23, 24. Now, one can say, under the guise of religion, you should not transgress 17, 23, or 24. But, my lord, the answer to that is, if you ever do anything connected with 17, 23, 24, it is not religion at all. It goes out of 25(1). So those 3 articles are standalone articles, but it is expected that anybody who exercises any right will always keep these 3 injunctions in mind, my lord. These 3, that is 17, 23, 24, are complete, my lord. They are prohibitions to be observed religiously.
It cannot be a part of conscience then.
That's, my lord, neither conscience nor religion.
Yes.
So it steps out, shall I say. So there is no conflict. The point I'm trying to make is, my lord, so viewed, 25 is conflict-free, 26 is conflict-free. The other articles go with it. And therefore, my lord, that 14, 19, 21, the trilogy, why doesn't come walk in 25, 26 is because the space occupied in 25 and 26 is of a substantially different character. It is of a personal, experiential, subjective.
Can we put this way? The religious faith of an individual to reach the ultimatum necessarily along with the tenets of the denomination.
I completely agree. I couldn't have put it better. I completely bow down to your lordship's observation. This is, my lord, really the sum and soul of the constitution, which is why, my lord, this right 25, 26, if we read other implications or other rights in it, you will have what is it you will be able to do? Because you have to be free to be able to even do what you want to do under 25.1. And as I said, my lord, there is no unilinear passage to the ultimate, as your lordship said. It is full of twists and turns, and there are many trials and tribulations. Nothing, my lord, happens in that journey easily too. If that is so, my lord, this is one of the most sacred freedoms which has to be preserved. And if this is central, my lord, to the existence of a human being, namely conscience. Now, my lord, can we make conscience? Let us take the case. Can we make it subject to what we call as intelligible classification by intelligible differentia with a rational relation to object? No. Because, my lord, the space of faith is intrinsically different. It's a completely different freedom. Its freedom, my lord, does not qualitatively ever come close or akin to, and that is the answer, my lord. It does not come entirely akin to, shall we say, any of the freedoms under 19. But now, my lord, I want to answer a question.
19 and 21 are essentially against the state.
They are, my lord, they are substantially, my lord, against the state. The fact in some judgments, your lordships have said that they could have had horizontal implications does not make them horizontal rights interposing their way into 25 and 26. My lord, that horizontal is, again, it has to be, my lord, read within a boundary, that expression horizontal. That word horizontal does not imply that it seeps into all these rights. The reason, my lord, why the individual and the collective are different is the collective has to adhere to the tenets and he has to actually function, as your lordships pointed out, A, B, C, D, different yardsticks in A and B, C and D. That is why, my lord, that along with what Justice Bijon Mukherjee, what Justice in Devaru said, under 25.2b, which your lordships could see in Shiru 25.2a. So therefore, my lord, 25.2a, 25.2b exhaust the universe of limitations by legislation. Simultaneously, you have, my lord, that public order, health and morality. Although, my lord, public order, health and morality may have different meanings in 25 and 26. They need not necessarily have the same meaning in the facts of a given case. They can have slightly different implications. But to be fair, my lord, there was one question which my Lord Justice Bakshi asked, namely, if suppose somebody disagrees with the tenets of a denomination, should he not have the right to express his views? Well, now I'm looking at a 19.1a intersecting in the space covered by 26b. I'm testing, my lord, the position that do rights of individuals get diffused into some sort of totalitarian oligarchy, which is called the denomination, and they cannot express themselves. My lord, as I said, even denominations are meant to behave with sensible approach, and if they do, they have to welcome debates. As your lordship said, my lord, the reforms which happen in society happen within society, from society. Right from Raja Ram Mohan Roy, my lord, every one of them has been a reformer within society. The whole Brahmo movement, my lord, was indeed, it was a rejection, my lord, of all outmoded forms of worship. Even, my lord, the teachings of Sri Ramakrishna were revolutionary in his point of time, they were completely unique. My lord, the teachings of Sri Aurobindo, logically, my lord, I agree with the Solicitor General that if you apply the test of denomination liberally, followers of Sri Aurobindo, who, my lord, believed in supramental consciousness, my lord, there's that book called The Ascent of Man. It's one ascent of man. And his collected essays on Gita, my lord, again, prolific scholar. His poem, my lord, epic poem, Savitri, is something which would match with Milton's Paradise Lost any day. So undoubtedly, your lordships are right. The same principle has to be followed. Now, why is it, my lord, I'm saying denomination, please give a liberal interpretation.
There need not be a rigid organization as such.
My lord, it is an organization, it's a registered society.
Necessary.
My lord,
It is
I understand.
necessary to have a rigid organization.
No, my lord, it's not necessary. But, my lord, organization, they said,
If a collection of people following
yes,
particular, you see, type of faith,
yes.
if there is no rigid organization, can you say they are not a denomination?
No, you cannot say for want of organization, but I must tell your lordships as a matter of fact, in the Sri Aurobindo case, there was a proper registered society. It was called the Sri Aurobindo Society, registered in Pondicherry. And that is where, my lord, the books were published, the printing was done there. And, my lord, this is one of the, if I may say so, therefore, the threefold test in Shirur Math is very easy to fulfill, my lord. So please don't think that it had to necessarily follow a unique teacher with special qualifications, because, my lord, if your lordships don't agree with my interpretation of a widespread definition for denomination, denominational temples will lose protection under 26. My lord, that is a very serious consequence. Denominational temples, my lord, the right to pursue religion by groups is a substantive right under the Constitution. It should not be defaced by interpreting the word denomination, that you please tell me what is exactly the Siddhanta which you are following in a given case. That is why, my lord, I said, if your lordships read the word religion as established faith, that is various religions, and you read religious denomination with religion, it's clear whoever belonging to whichever faith coming together. My lord, it will completely solve, shall we say, all this about a denomination. Now, my lord, I want to quickly finish. My lord, just two more points. My lord, I now want to say one thing, my lord, about 14, 19, and 21. I have made the point. But, my lord, I must say that the judgment in the electoral bonds case, employing the fourfold test of proportionality, my lord, is not necessarily the only way to interpret articles in a constitution if they are coming into tension with each other. My lord, that is not the only way. And that way, my lord, is actually very unique, my lord, to the European Court of Human Rights. And because England was a party to the Human Rights Act, and therefore, my lord, as a public authority, Baroness Hale, in the judgment, my lord, in Campbell versus Campbell, had to undertake what is called the balancing test. My lord, their rights are worded that you have to balance. There is nothing else you can do, but you have to balance. But yes, conceptually, my lord, there may be a need to balance. And that is why, my lord, Devaru is a judgment which did not use the word proportionality. It used the correct word harmony. And harmony, my lord, is the quintessence and the soul of the Constitution. My lord, as far as the facts are concerned, I have stated them. I don't think I'll take a moment more.
Thank you, Mr. Well,
Grateful, my lord. If your lordships have any questions, I'm more than happy.
thank you very much.
Thank you.
Some doubts are solved. Some doubts are solved.
I'm grateful, my lord. I'm grateful. And, my lord, I must thank Ms. Jai Singh for enlightening us with an extraordinary address. It was truly extraordinary, memorable. And also my colleague, Dr. Dhawan, who, my lord, inspired me with many of the ideas. I'm grateful to him.
It will use non-essential
That's how it has to go. Yes.
Lord, the arguments on the other side boil down to one proposition and one only. And it is from that proposition that everything else emerges. The proposition is that there is an assimilative way to read fundamental rights. Now, this assimilative way started in 1970 in R.C. Cooper, went into Maneka Gandhi, went beyond in Minerva Mills. And this is responsible, Lord, for a large part of the interpretive problems that we have. If everything can be assimilated one upon the other, 21 will be read into 26, into 27, into 28, 14 will be read into 21. The so-called horizontal rights, I don't like the word horizontal rights, my lord, because in sociology we mean it as vertical and horizontal, but anyway, we'll use it. Horizontal rights will be read into everything, and that assimilative interpretation would in fact destroy the entire construction of fundamental rights. I'll elaborate that later, but let me begin, my lord, by more generally on where we are in agreement. My lord, we have a huge constitution. I have divided it into 10 texts. I won't bother your lordships with all of them. That's the only way to read it in my view. But I'm going to concentrate on two texts of the Constitution: the justice texts and the political texts. Your lordship is concerned here with the justice texts. I'm not saying that Parliament is not concerned with justice texts. Of course they are. When your lordship exercises the justice texts, there are a huge apparatus of concepts that you can use when you are balancing, when you're using proportionality. Double proportionality is actually taken from algebra, but whether you should use it or not is another matter. And therefore, my lord, when your lordships are looking at the political text, your lordship exercises the rule of law. That is what your lordship is saying to them. You have been given power by the Constitution. We will not let you cross the rule of law. Therefore, there is a fundamental difference between the custodian. I can actually see you, my Lord Justice Amanullah. Where I was sitting, this actually, I could never see your face. But I can now. I'm grateful for it.
I hope it's not a distraction for you.
It's a very pleasurable face and nice to look at.
Thank you.
Unless you ask me angry questions, which is another matter altogether. But at any rate, just bear this in mind, that you are not exercising jurisdiction over the political texts. I'm not saying the political texts are not important. They gave us the basic structure doctrine. They gave us the doctrine of nexus. They gave us the doctrine of colorable legislation. All that was yours. Where we are on common ground, starting with Ms. Jessing, this is in fact a social document. It has a social document going into futuro, and it is a social document of the most diverse country in the world. No other country has to adjudicate the problems that your lordships has to adjudicate. Kindly bear in mind, that is why I am very averse to pulling out precedents from other countries unless they help conceptually. We are also agreed that the reform process is the most important process in the minds of the Constituent Assembly members. And this goes to the interpretation of 25(2)(b). Probably it's autonomy, but this goes to that. And there we are also agreed. Mr. Sanjay Hegde was right in going back to 1926 to trace the movements that had taken place. And my Lord Justice Baravale then corrected one or two aspects of it. So alongside, if this country does not do social reform, it is lost. It is lost totally and completely. My third point, my Lord, as far as this is concerned, this country does not just exist for individuals. It exists for groups and institutions. And I will demonstrate that. Written into even the fundamental rights chapter are the rights not just of individuals, but groups. As soon as you come to 15.3, you come immediately to the concept of a group. And how many do we have, my Lord? And how many do we have to offer? SCs, STs, EWSs, women, children, the degradation rights, they all belong to groups. Unfortunately, what has been argued from the other side is a massive investment in the concept of the individual. And 26 is a group right. 29 is a group right. Call it horizontal, call it whatever you like. 30 is a group right. And now, my Lord, I'm trying to go back into what was in the minds of the constitution makers. Let us look, my Lord, at the grouping of the articles in 25. If I can find it, otherwise I'll ad lib, my Lord. Firstly are the libertarian and the egalitarian rights, 14 to 18. This was uppermost in their minds because if these rights were not given, then the entire freedom movement would have come to naught. Because speech was taken away. Unfortunately, sedition, my Lord, is there still. Speech was taken away. Equality was taken away. All this was taken away. So if they did not have these libertarian rights, the very promise of the Constitution would disappear. And I therefore put it in that context, that this is one particular area, and I don't want to read one right into another and one area into another. Now, my Lord, by and large, your lordships have resolved the questions of 14 to 18. This is no longer controversial. Possibly Kaushal was the last case where such controversies had to be resolved. And your lordships have to, I mean, we on this side are still concerned with preventive detention and bail, but that's another matter. Your lordship has to resolve that as well, because that is also part of 14 to 22. The preventive detention provisions have not been given the presence that they had in the early 50s after Atmaram's case was decided in 1951. Now, that was the first object related to the freedom movement, to give protection to everybody and equality to everybody. Then comes, my Lord, what else did they think of? In my view, they thought of religion as groups and religion as individuals. And so they gave rights, and your lordships and ladyship are right, it goes all the way to 30 in one sense. But I'll separate them in a moment. As far as the Article 30 rights were concerned, your lordships have resolved those as well. We are now in a very interesting situation. TMA Pai, followed by Nagaraj, has made it abundantly clear as to what the direction should do. You will be faced with political questions as to whether you can go beyond 50% or 70%, but the foundation of that has in fact been laid. The third big area was the area of school, language, and religious education. that area is also been resolved by your lordships. TMA Pi and everything was followed from it. The one area that remains unresolved is the right to religion, going all the way to 30. And that is what your lordships have to resolve, in my respectful view. I realize that in the complexity of India, this may not be possible, and it is certainly difficult. I use the word balancing as the decisions taken by your lordships. The rest are techniques. Balancing is that difficult part of judicial decision-making which your lordships, my lord, have to look for, find within yourselves. That very famous passage, my lord, by Justice Patanjali Shastri in V.G. Rao, where he says, and also the conscience of the judge. Now, we cannot, my lord, lecture to your lordships on how balances are to be worked out as an interpretive tool. That is your job, and only your job. You have the experience to deal with it. So let me come back, my lord, to this. My lord, it is said, and I borrow this from Walt Whitman, that India is so complex. To borrow his phrase, It was the biggest mutt in Bengal in the Mohammedan period. It traces its period to the Mahabharata. There had been a lot of litigation in regard to this mutt in the district court and in the high court. Most of the properties of the mutt have vanished because of either mortgages or sales or long leases and the like. Another instance of this kind is the Takeshwari mutt. Court schemes were prepared, and as a result of certain complaints regarding the working of these institutions, within a few months thereafter, litigation commenced. Third line from the bottom, most of the mutts in the north, as well as the south, were maintaining pathshalas, tolls attached to them for the propagation of Sanskrit studies. They were running religious charities like gosalas, dispensaries. Most of the pathshalas are now closed down for want of students and are not maintained properly. To some extent, this reality may be due to the change of ideas from generation to generation, but it is also due to the fact that there is a tendency amongst many Mattapadis to treat the institutions as their private property and utilize most of the resources for themselves. Then comes 3 lines later, many are not even versed in the first principles of the Hindu religion. Not to speak of the fact that they really make little attempt to propagate or promote the religion knowledge. The need for remedying this state of affairs is a matter of urgency, and the steps that we consider, read that. Next paragraph. All mutts served a purpose according to Hinduism. And then the third line, but mutts managed to secure large powers of property at their disposal in the British system. Then, my lord, about 8 lines from the bottom, one view is that custom had been given powerful religious functionaries vast wealth, properties, powers, status, and they should retain their customary powers and privileges. The other was that they should be denuded of all the appropriate shares consistent in the limited needs. The report noted the extravagant claims by the functionaries of the Dakshina temple in Calcutta, the Nathwara temple in Rajasthan. Put on a comparative scale, they were not the worst of them. And then, my lord, they gave further examples. Then, my lord, kindly come to the page 35, second para. Many big temples and mutts were richness personified. For example, the Badrinath temple had ownership in palatial buildings in Dehradun, Lucknow, Calcutta, Bombay, and perhaps other places. Kedarnath in the previous year had income of so-and-so with surpluses. Nathdwara had jewelry and surpluses. Jain trusts also then are...
I think ultimate conclusion is at page 40, Mr. Dhawan.
Yes, no, I'm just saying in page 36, you'll find the surpluses.
That's correct.
At page
No,
40.
that is my conclusion, and I don't want to read it.
Yes, yes. That'd be better.
Because I have actually summed up this in my own words.
That's it.
I may have got things wrong, my lord. I write my own submissions and first by hand. So there may be a few problems here and there, my lord. Then, my lord, when we go and I just want to read one more, page 37, and your lordship have got the picture. That is on page 37, second para. Chief Minister B.C. Roy complained to the commission that private temples were collecting huge public donations. The Kalighat temple had huge areas by the Nawabs of Bengal, which the Shibets sold, and the Shri Krishna Mahaprabhu temple at Nabadwip was grossly mismanaged, and the 100 Shibets attached to it. The old Calcutta Kali temple belonged to the Tagore family, and the descendants not only claimed it to be private, but took advantage of the concessions from taxes as a private temple. In Assam, Baduri temples and elected Deloys made most of the money. So, my lord, it's not as if they didn't know because of one campaign. It is a major part of the reform Sometimes, my lord, we think of reform, let's have a uniform code because we can get Muslims into it. We overlook the fact that the origins of Article 25(2), social reform, has a very wide implication, and anybody who has been anywhere in India will recognize the importance and probably the autonomy of 25 to A and B. So I stop on this. As my lord, the Chief Justice puts it, there is more to read. But let me come back, my lord, to my main argument. My main argument is my summary of the argument on the other side. So this was important, my lord, for us to remember that this is one of the unsolved areas in the fundamental rights chapter. Constitution benches have taken care of other parts, but this is the unsolved area. Now, my lord, kindly come to page 2. I'll read it because it's easier to explain my view of why their basic argument is wrong. 1.1. The basic right to freedom of religion, 25 to 28, rests in the individual freedom of conscience and the right to freely profess, practice, and propagate religion in 225.1. This is not my argument. This is my paraphrase of their argument, that the nodal right is in fact 25.1.
That's why your heading shows the arguments of the respondents appear to.
That's right. That's what they've argued, my lord. And I believe that this is the basis of the argument that they have raised. And it attends everything else that has been argued. Arguendo, it is these individuals who form a community as a denomination or section. We have to make a difference between a collectivity of persons and a community. 25 is about a community. It is not about a collectivity of people who have simply gathered there and suddenly elected a leader. It has some purpose to it and has to be, as my learned friend Mr. Subramaniam said, defined widely. The next, therefore, the restrictions on 25, according to their argument, especially the restriction in other provisions of this part, also governs 26, which is argued cannot exist on its own and depends on its existence to Article 25. Therefore, their argument is 26 cannot exist on its own. In fact, Mr. Srivastava took it even further and took it all the way to 28 as well. Now, my lord, it is argued, and this is where the origins come, that the bank nationalization case, Menaka Gandhi, took an assimilative view of constitutional interpretation, supports the view that each right is not a silo. Now, my lord, sometimes we use very emotive words. Silo is a very emotive word. As if you were to say to me, Rajiv, you are a silo, I would actually be very offended. C.L. Stevenson, in a famous article in 1939, said this is called persuasive definition. So as soon as you move to the silo, suddenly you say, what's happened? Can articles be silo? No, they're not. They're independent and autonomous. Therefore, it is argued, constitutional morality has to be read into 26, not just as interpretive values to be considered, but as a limitation on the institutional rights bestowed in 26. This is a further consequence of this assimilative approach. The doctrine of essential practices is useful so that only the core of religious rituals and practices are protected, and specially useful to decide interfaith and intersect disputes among believers. That was Mr. Jay Gupta's argument. I will show to your lordships that all the cases that he cited do not support this. Why would you separate that only separately, that we use essential practices only for private disputes? Balancing is an intricate judicial task to weigh, it's a W-A-Y, it should be weigh, various factors and values to come to a decision on law and determine outcomes. I think this is what Justice Bakshi had in mind, that this process is to determine outcomes. It is not the methodology. through which we reach the decision. It entails considering the rights against the restrictions using various juristic techniques such as reasonableness, proportionality, double proportionality, due process, and the concept of a just law. Although Indira Jaisingh didn't specifically advance this, I accept what was implied in what she said, that when we talk of law now, we talk of a just law. And this should be, other things remaining the same, using a ceteris paribus clause. This is how we perceive law after Maneka Gandhi, Cooper, and others. So, my lord, this is the argument, and these are the implications, and like an octopus, it spreads everywhere, every part of the interpretation. The basic argument is privacy, individual conscience, individual freedom to pursue the faith, and it is individuals who make communities, create rights, even though religious groups and institutions predate individual existence, and most are born into the faith with the right to differ, reform, or renounce it as they please. I'm a pre-independence child, my lord. I didn't choose my faith, I was born into it. So this idea that suddenly you come to a community and all of a sudden you choose it and you choose dissent in it, Lord, this is a falsification. Dissent does exist. You have to protect conscience. As Mr. Subramaniam put it, that conscience is something that you cannot go into. As soon as you go into the area of professing, practicing, and propagating, that is an area of judicial examination. Now, my lord, having said this to be their basic argument, if your lordship accepts that there is a centrality to it, then, my lord, there is something in what I say. If not, my lord, I give a walk over to them and take their position as. Now, what did the constitution make us?
You are giving on the theory of constitutional interpretation.
That's right.
When it comes to these articles, because they were really not considered as such by a 9-judge bench. It was individual cases.
That's right.
There was no collective consideration earlier by this court.
That's right. Lord,
Therefore, the 14, 19, 21 triangle cannot be straight away applied is your argument.
I want to add to that, because it's a point I'm going to make, but your lordship question is a fundamentally important question. In all this assimilation, none of the rights assimilated lost their individual identity. If Article 14 question comes to you, you will still look at classification and arbitrariness. If a 19.1a question comes, you will still look at 19.1a and 19.2.
Yes.
Only thing that you will see is that the concept of reasonableness has been extracted by this assimilated process. So when you look at 21, and the history of this court is interlinked with 21, you will look at 21, you will look at life, liberty, and law and interpret them in the context of 21. So the identity in this assimilative process is never lost. That's what I want to argue, my lord. And then, my lord, I asked myself, what did they have in mind? The first thing they had in mind, of course, was individual conscience and religion. But they were a little fearful of what the manifestation of religion can do. Not the conscience part, the manifestation. As Justice Amanullah put it when superstitious beliefs were being discussed, it's not the beliefs, but how they are of professing, practicing, regulating, you enter into a social area. Now, what did the constitution makers want there? The constitution makers said, we can't leave this as a right which does not have restrictions. We just can't. Because in its manifestations, it could give rise to the worst communalism in the world. But they added one more. Other provisions of the Constitution. Can you give me a Constitution? Other provisions, just have a look at it. It's a play on words, like Ma'am Guru Swami's play on words on what is managed, etc. It may be just a play on words, but I'm bringing it to your attention. It says, and to the other provisions of this part. It doesn't apply to itself. If it doesn't apply to itself, how can it be transferred to 26? It says the other provisions. It was conscious that the libertarian provisions, the equality provisions, the reform provisions for women and children in 15.2, untouchability, whatever it may be, all that will apply as a restriction. Because they were not sufficient with the police power being public order, morality, or health. And that is the reason why this had to be controlled, because we are a country with a huge amount of religious tension and group tension. And there is no point denying that we are not. Then, my lord, they faced another problem. They realized that group rights exist in India. India does not exist as individuals. It exists as groups and institutions. That led, my lord, to Article 26. And the only restriction that was placed was the police power. Then, my lord, they confronted another problem. This is a problem that goes to secularism and some conflicts between K.M. Munshi and Nehru on Somnath as well. Munshi wanted Somnath constructed, and Nehru's view was you can't do it with public money. So if you want to decode, of course, the controversy came later, but it is there in the debates. And so they said that, look, there will be no taxation for a particular month. We are a secular state, and therefore I call this, my lord, in my writing, celebratory neutrality. Rajiv Bhargav says principal distance. These are a lot important concepts from political theory that have come. That led to 27. 28 was the biggest problem of all. Catholic schools. Lord, the domination of India for the last 75 years are people educated from convent schools. They've done very well. The others are coming up. And they were very concerned. First principle was secularism. The state, you will not, 28.1, the state will not impart religious instruction. This came to your lordships, my lord, in Aruna Roy's case. She said it was religion. Your lordship said it was culture. It had to be interpreted. But the more difficult one was, if you are not getting aid, then fine, you can do what you like. But if you get state aid, what should you do with students? Will you give them religious instruction? I went to a boarding school. Principal wrote to my father, and he said, would you like your son to attend chapel and religious instruction? My father said, oh, certainly. And so I spent 5 years in the choir, which I absolutely didn't want to go, but I learned a lot about Christianity. At any rate, that was the purpose. And in TMA Pi, Chief Justice Kripal takes the view, no school can survive without aid. All of them are aided. St. Stephen's couldn't survive without aid. Convent schools can't. And therefore, this was a very important issue. We are giving aid to all these people. And it was a point raised by Govind Ballabh Pant. We're giving aid to them, no compulsory religious instruction. So that completes. Now, what do you do with the other variety of India? 29. It is in general terms. I won't read it out, my lord, your lordship has read it over and over again. 30 is in general terms. Now here, 30 posed a problem. The problem was that Justice J.C. Shah in 1963 said that because there are no limits here, that means it is absolute. When the matter came before the 11-judge bench in TMA Pi, they said this is not correct. No right can be absolute. If they have property regulation will apply. If they discriminate, of course, India doesn't have a social anti-discrimination law. If they have bank accounts, all that regulation will come into this particular process. Then they had to regulate students. How many? St. Stephen said 50%. And now, of course, we have all that problem. And that you must show the words establish and maintain are there. One controversy still remains in AMU. Was it established and maintained by the religion? But these controversies were all solved. So what was in the mind when faced with this diversity, faced with the pressures, faced with all the requirement of reform, what did they want to do with these articles? The one thing that was almost clear is they did not think of them as silos. So I complete that point. I don't want to labor it anymore. I go, my lords, into the next question. On page 4 onwards, I'm not going to read it.
In fact, you have explained well already this part.
Yep. I'm just supporting that argument, my lord, that these are the group rights that have been recognized in our constitution, with national commissions to support them all the way. And the most interesting one is Nagaland. No act of parliament in respect of religious and social practices, Naga customary law, administration of criminal justice, ownership and transfer of lands can be done by the central government without. So here is a huge range of protection. Can we put it in a silo? We can't, my lord. Next, what I come to, my lord, Mr. Subramaniam has already argued that there are no hierarchies. So I've got a page on it. I'm not going to, my lord, take your lordship's time on it. I also take the view, which was expressed by Mr. Vaidyanathan to me, and I think this had a little ring in what the Solicitor General said. Why are there so many restrictions? But I'm going to leave all that. So kindly come to page 8. Here is where I give my response to the assimilative argument. Since I've already argued it, my lord, I am not going to go there.
Yes, but
There is no point going there. The important thing, my lord, that emerges is actually at the bottom of page 7. While you are looking at these rights, what are the techniques that you use? The first and foremost technique was given to us by the constitution makers. Restrictive. Is it restrictive? Is it not? And they use many phrases, subject to, notwithstanding, phrases like that. So the list of restrictions in the text and limit in the rights in question was what the first juristic technique was. Restrictions was to specific articles and crafted to them not susceptible to be transplanted. Where two rights or provisions are of equal status, the interpretation would be to give full effect to them by harmonization. And I think a number of us have stressed what harmonization means. If they are of equal quality, then you will try to give effect from both. Whether Devaru did this or not is another matter. Because Devaru, in fact, said that 26B will be subject to 25 to 2B. But that is for your lordships to decide how your lordship does it. Then, my lord, in using religion comes with what I call balancing. Balancing is a judicial task. We can only assist it. It's the most difficult task that your lordship has. Your lordship goes through it every day. Reasonableness goes hand in hand with proportionality. And then they've been given the last one, which I borrowed from the other side, that law must mean just law. So even if there is a law, say of temples, it must be a just law.
Yeah.
If procedures are required, then the procedures should be followed. How your lordship will modulate it, my lord, is up to your lordships. Then, my lord, what I do is on page 8, I give the Cooper argument, and on page 9, the integrity. And then, my lord, why I argued, the argument is reductionist. That's page 10. In the present reference, the propositions of the respondents are plainly reductionist in the following way. The individual right to conscience and freedom of religion is given total primacy. That's a reductionism. In a fairy tale way, it assumes individuals by some imagined social contract create a denomination whose rights are no more than the rights of individuals. This is reductionism. There is a failure to recognize that denominations often are not always consciously created, but emerge over time and predate individuals born to them. There is a qualitative difference between a collection of individuals and a denomination and section of a religion which establishes and maintains institutions, possesses rights of management over, I would say, all religious affairs, own property, and administer property according to law. This is the qualitative difference between a collection of people and a collectivity called a denomination. The institutional rights are derived from 26. When I began, my lord, in my first address to your lordships, I said 26 is the most important right. Without property, without organization, no religion will survive beyond a few months, because they survive on institutions. They survive on the Pope, they survive on the mosques, they survive on the temples. Take them away and interfere with 26, the very longevity and the future of a religion would completely disappear.
In fact, the denomination or the organization, it holds the people together to a particular philosophy or religion.
Quite right.
Therefore, it is required
Whatever it may be.
perpetuation of religion in this country.
That's right. Because if you want a religion to proceed, somebody has to do it in an organized way with property rights, with autonomy, managing all its affairs. Now, this Guru Swami then said management is different from control. This is just a lexical argument, my lord. I don't even want to reply to it.
Control is part of management.
Sorry, my lord.
Control is one of the part of the management.
Yes, of course, my lord. We can't. It is linguistic quibbling, my lord.
Page 13, you have explained all these things.
And then, my lord, how 26 is limited. I don't do anything. Only thing is sub-Romans 7. Most important, such a change in 26 will totally denude it of its purpose and restructure both the right and limitation. I've already emphasized that. Now, my lord, I come to over the page, if your lordships will come. I'll ignore all this, my lord, if your lordship has time, and I doubt. I come to page 11, bottom of the page. I've changed my view on horizontal rights, my lord. I don't think they can be attached to any other right. They are self-standing. They are universal values. Each of the restrictions are there. Horizontal values can enter into a decision, but they certainly are not a limitation on the rights that exist. We have to make a very important distinction between a value which enters your lordship's judicial imagination and where, like a threshold practice, it becomes a limitation. And the difference between evaluating something and making it a restriction or a limitation, my lord, is fundamental to our understanding of part 3. I'll come over the page, my lord. I will not go into all this for the next 2 pages.
26 also you have well explained.
26, my lord, I have actually dealt with.
Yes.
Your lordship is moving faster than me. Sometimes we call it a sign of impatience. I hope it isn't that.
Because your note is very crispy.
That's very kind, my lord. That's very kind. That's what Mr. Subramaniam tells me, but I don't believe it. Finally, my lord, I come to essentiality and integrality. My lord, there is a difference between a threshold interpretation of essentiality and integrality. Now, what happened in Sabrimala? I'm not enlarging. They said this is not essential to your faith. What was the result? It was a limitation, and they had no Article 25 rights. The 25 rights, if you treat it as a limitation, 25 rights will completely disappear. Likewise, in Sabrimala, if you did not give them denominational rights, 26 disappeared. And this is the importance of the concepts of essentiality and integrity on the one hand, my lord, and, my lord, denomination on the other. If there are threshold requirements, the effect will be 25 rights and 26 rights will be invalidated and they can never have the rights. Beyond that, my lord, essentiality serves no purpose. It can only be divisive. One of your lordships may say, look, this is essential. Another may say, this is unessential. Not in the same case. And it has happened. And therefore, my lord, your lordships are not the high pope or the high priests to wander into this particular area. And essentiality and integrality will take your lordship straight into it. The other argument as to how it was evolved, I've already done, my lord. I just want to add 2 things. My lord, kindly come to page 15, sub 3. This is my interpretation of Durga Committee and Tilkayat. They are arbiter. And the reason why I say that is because the actual decision that was made in Tilkayat was, Nathdwara temple, that he had no rights. He had no anterior rights, therefore they decided against him. Now that is the ratio of the decision. The rest is all a carryover. Justice Gajendra Gadkar, I don't mind saying so, was a reformist, and he saw this opportunity for reformism. Similarly, my lord, as far as the Dargah Committee was concerned, the Khadims raised the question, and once again, Justice Gajendra Gadkar took a huge exploration into history and said, by the way, you'd never had these rights. So really, these are actually limited decisions if taken to the ratio decidendi. Now, my lord, I am not going to core beliefs I've done. Page 16, my lord, I'm not going to read them because Mr. Jayagupta and Ms. Guruswamy gave certain examples. All those examples are, in my respectful submission, wrong. For example, Ms. Guruswamy said the quarrel was who would appoint priests. Nothing. There was a power struggle taking place. That's what it was. No essentiality was involved. Muhammad Hanif is decided on the basis of animal husbandry. Small part is essential practices. So all those examples, my lord, I'm not going to take your lordship through it, my lord. That's the end of it. But I will take you to one question on page 18 and one table, and then I'm done. My lord, I have placed this before your lordships and so I'm going to place it again, but I'm not going to. While constitutional morality is certainly the creation of Chief Justices Mishra and Chandrachud and others, Chief Justice Chandrachud also gave a decision in the Madrasa case. And the question was whether basic structure could invalidate a statute. And this is what he says. It can be concluded that a statute can be struck down only for the violation of Part 2 or any other provision of the Constitution or for being without legislative competence. The constitutional validity of a statute cannot be challenged for the violation of the basic structure. Here is his reason. The reason is that concepts such as democracy, federalism, secularism are undefined concepts, allowing the courts to strike down legislation for violation of such concepts will introduce an element of uncertainty in constitutional adjudication. Recently, this court has accepted that a challenge to the constitutional validity of in violation of a basic structure is a technical aspect because the infraction has to be traced to the express provisions of the Constitution. Now, if there is relativism in basic structure, it applies to constitutional reality, morality.
But this approach was not applied earlier.
Sorry,
If Justice Chandrachud did not apply this approach in Sabrimala.
exactly. That's the point I'm making.
This is 2025.
The entire generation that has created. I told your lordships that in Narula's case, which was argued by Mr. Dwivedi, he kept saying corrupt judges should not be part of a cabinet. And Justice Deepak Mishra said,
Ministers, please.
MPs should not be part of the cabinet. And what was said by
Corrupt ministers.
And what was said was this: actually, we repose a constitutional trust in the Prime Minister. So morality became a constitutional trust in the Prime Minister. All those have been placed before you, and it was placed very well by the solicitor because he made our task much easier because he read everything. And the one good thing that he read, while everybody was quoting passages from the Constituent Assembly debate, when he quoted a passage, he said, this was not agreed to by the Constituent Assembly. The decision is as important as what they said, and that made it our task easier. Now I come to the last, my lord, the extent of judicial review. What I've done here, my lord, is I've put down the article, the prescribed limitation. My Lord Justice Bagchi has it. So Article 25(1), I've given what it is, what the prescribed limitation is. I'll just take two examples and it will help. What must the court do? Judicial review in each case will be different, not case by case, but class by class it will be different. The court must examine A, whether the claims are based on a bona fide belief. If not, the case goes out. Next step, interpret the extent of the freedoms guaranteed. Interpret the prescribed limitation. Apply proportionality. Ensure that the law is fair and just. Give due respect to directive principles where applicable and as reflecting the values underlying the Constitution. Now, what I've done is, for each one of these, I have in fact indicated how your lordship can proceed if your lordships are so advised. And my lord, it is not a question of how high or how low the judicial review is. The question is, what is the judicial review in this case? My lord, I've taken a lot of your lordship's time. I'm extremely grateful.
Thank you, Mr. Ram. Thank you. Vivek. Who yesterday did not turn up very difficult one. We can't accommodate now everyone. Yes, Mr. Dwivedi.
Well, I have a very short note, so it won't take much time.
Today.
In some ways, Lord, I'm responsible for this constitutional morality. I wanted the corrupt member of parliaments not being made ministers, Lord. So I wanted to restrict, not judges. The argument was that when the prime minister selects, Lord, the ministers, then he
We
should
recollect
look,
that
he should
after-
look into this, Lord, because what are we going to have, Lord, if every corrupt person?
Dhawan also meant that,
Yes.
but sometimes the words are so.
But I did not know, Lord, that this will be the slide of this constitutional morality, that it intervenes everywhere, Lord.
We hope it was only a slip and not intentionally said.
Yes. Because just two caveats. One, Dr. Dhawan Malan cited a quotation from the esteemed learned counsel, Lords, late Mr. Fali Nariman, Lords, where he says, Hinduism is a way of life. But I disagree with this, Lords. All religions have a way of life, but they are much more than that. Hinduism, Lords, is a religious philosophy also. It presents a social structure also, how man relates with the creator. So it's so much more. What is the man's existence in this world? So this, Lord, crept in one judgment of this court, Lord, the Hinduism is a way of life, and that appears to be from where Mr. Nariman picked it up. I hope your Lordship will not endorse that, Lord, that is simply a way of life, Lord. That completely dilutes the essence of Hinduism. And the second, Lord, is with something which I agree, Lord, completely, that 25 and 26 are group rights, in fact, massive group rights. But the 25-1 is a fundamental right, Lord, where the individual right and the group right coalesce. They stand intertwined. Because I had earlier said in the main argument that religion is associational by its very nature. But one man in Robinson Crusoe's island, Lord, is he can't. He may do meditation, etc., but yoga, but it can't be a creation of a religion. So all these religions which are existing, they are associational in nature. And conscience, practice, propagation, all these can be exercised by groups. Groups are nothing but collection of individual judges. That is what Lord Shirur Mutt said. In fact, when it was argued that institutions don't have, they said the question doesn't arise, but what we think is that even in institutions, it is individuals who carry on, it's a collective conscience. When people group together, then it becomes a collective conscience. So it is both an individual right. The practices can be done at home individually. It can be done collectively by me in the temples or in the mosque or in the church. So, but predominantly it's a group right. The fact that individuals can also exercise these rights individually, that does not mean that it ceases to be a group right. And when we talk of 26 religious denominations, that's a narrower subset, which, because of the historical significance, which our lordships have all heard during the course of arguments on our side, because of that reason, my lord, they were given special status as a fundamental right with special additional protections. They were taken out from that. So non-denominational institutions will still be under one. It is only denominational. And denominational, whether we call it sampradaya or otherwise, my lord, sampradayas are in all languages. It's not simply Hindi. We need not, my lord, go to Hindi dictionary, English dictionary. Sampradaya exists, my lord, in Tamil also, my lord, in Kannada also, in Malayalam also, all languages. And as Justice Amanullah said, Lord, even Muslims have sampradayas. So sampradaya is not something, Lord, which is an abhorrent word, and therefore religious denomination is really meant to be that only. And because of that character, my Lord, these special rights have been given. And I had urged earlier, which I reiterate, my Lord, that it should not be diluted, my Lords. It has played a great role in keeping Hinduism alive and the nation, my Lord, building. Now, with these two, my Lords, in fact, my Lord, in my humble submission, every individual right which is there in part 3 also simultaneously in an intertwined manner has a group dimension. One doesn't speak, my Lord, or express oneself in an isolated room. One also speaks, my Lord, when in seminars and associations, in parliament, in court, my Lord, it's a group right also. And it is meant to generate ideas, my Lord, which are useful for the nation. And that's why, my Lord, these individual rights are given. So there's an interaction of individual and group everywhere. If I may only advert, my Lord, to two expressions. One is in African, my Lord, and one is in Sanskrit. In African, they say, my Lord, Ubuntu and Gamuntu and Gabuntu, which means, my Lord, I am because we are. And in Sanskrit, my Lord, it's the reverse way and a better way. Vayam smaha tasmate aham asti. We are, therefore I am. So the group comes first, and because of the group I am. And in English, one can also say, Lord, that who lives if the nation dies, Lord. So the group, Lord, ultimately in religion also, if the religion is to be preserved, the group entitlement is of immense significance, and it should not be diluted, Lord. With this, Lord, if I may come back, Lord, to one of the questions which my Lord Justice Nagaratnam, Lord, had raised, and I must confess, Lord, that we should have put more effort on this question as to what is the significance of subject to other provisions of this part. The first, my Lord, is that when we are faced with this expression subject to or non-obstante, then we do not, my Lord, immediately conclude that whatever right is being conferred by the following words or recognized by the following words, it stands immediately subjected to everything which is in part 3. In the context of non-obstante clause, your lordships have said in judgments, Lord, that don't start with it. Look at what is being provided as substantially provided in the provision.
What follows?
Yes. What follows is the primary thing, and then you can determine, Lord, what is subject to and what is non-obstante. If your lordship comes to page 17, this is 11 judge judgment, Lord, Madhav Scindia's. Para 68 I have quoted. The article commences with the opening words, notwithstanding anything in this constitution. These exclusionary words are no doubt potent enough to exclude every consideration arising from the other provisions of the constitution, including the chapter on fundamental rights. But for that reason alone, we must determine the scope of that article strictly. The article goes on to say that jurisdiction of all courts, including the Supreme Court, is barred except the President may consult the Supreme Court. Having said this, the article goes on to specify the matters on which jurisdiction is barred. This it does in two parts. The first part is in any dispute arising out of any provision of a treaty, etc., which was entered into or executed before the commencement of this constitution by any ruler of an Indian state to which the government of Dominion was a party, and which has or has been continued in operation. This shows that a dispute relating to the enforcement, interpretation, or breach of treaty is barred from the court's jurisdiction. The word arising out of the provisions of treaty limit the words. Thus, if treaty covenant is characterized as forged by any party, that would not be a dispute arising out of provision of statute. So they must first spell out what is the context, what is the content of the substantive part, and then
Which was that article?
That's on a different context. It says notwithstanding anything, therefore,
Notwithstanding.
you have to consider.
so it doesn't override everything. That's what I'm trying to say. I will come to how we should apply to subject to.
Subject to.
Yes. Just have one paragraph also of the next judgment, my lord. A non-obstante clause is generally incorporated in a statute to give overriding effect to a particular section of a statute as a whole. While interpreting non-obstante clause, the court is required to find out the extent to which the legislature intended to do so in the context in which the non-obstante clause is used. So this is what I want to, my lord, emphasize, that when we come to 25(1), please see what is the content of 25, what this fundamental right. For it is this which is being subjected to. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. So it's the equality. All persons are equally entitled to, it is that. So one necessarily, therefore, when it says subject to, then one has to trace out those provisions which necessarily have an impact on this equality which is being talked about in this. For example, 17. 17, my lord, is an article which is an article of equality. When it prohibits untouchability, it brings in, it's an inclusive provision. And because of the seriousness of the exclusion, it makes it an offense. So prohibition coupled with offense. That's why, my lord, it has an impact on equality and it has to, this has to be subject to 17. Likewise, nobody can say, my lord, that any religious denomination or otherwise any religious institution can, despite the constitutional injunction in 17, still practice, my lord, this untouchability. That cannot possibly be argued, my lord. Therefore, it immediately gets attracted. Likewise, 23. Many religious
Interrupt for a moment. On these horizontal rights, what I indicated was that they would give rise to a constitutional tort.
Yes, we saw that. We saw that, no. Therefore, only suit will lie.
But I didn't emphasize it. I'm sorry to interrupt.
So Article 23, it cannot be said, my lord, that a religious denomination which has large amount of land, my lords, they can practice begar there, my lord, employ people and not have forced labor there. So therefore, these are provisions which impact equality and therefore will apply. It's not, my lord, that all other provisions of the part 3 straight away will apply. Article 30 cannot apply. There are provisions like Article 14 and 15(1) which are injunctions against the state, and therefore, my lord, on the face of it, it has no application to the equality fundamental right which has been conferred. So once we, my lord, identify this context and the equality principle which is enshrined in Article 25(1), then it becomes easy to locate, my lords, without entering into this horizontal and vertical aspect. It's the germaneness to the equality. If it is germane to it, it will have application. Either it will improve upon it or it may dilute it, whatever be the effect of it. For example, 16(5). It says Parliament can make a law, my lord, saying that in case of religious denomination institutions, only a member of that will be appointed. Now that's an improvement. So subject to doesn't necessarily mean, my lord, a dilution, a reduction. It can mean an enhancement or an improvement upon the equality principle. So it is only such, my lord, articles in my humble submissions, this subject to other parts. And the second aspect of this is that when subject, this should be read as a whole, subject to public order, morality, and health, because this is a empowerment to the legislature to make a law with regard to these 3 subjects. So identically, if you read it as a whole and to other provisions of this part, so therefore there has to be some provision in the other part of this part 3, which empowers the legislature to make a law.
Is there in 25(2)?
Yes.
Under 25(2),
25(2) is there.
they can make the law.
Yes.
That is the enabling power of the state.
Yes.
So that's this humble submission on this aspect. Then, my lords, I have, my lords, just pointing out to your lordships, note in page 3, refer to 4 competing structures which have been presented for acceptance, my lords. The first says that Article 25 relates to individual right to freedom of religion. I have already submitted, my lord, that it is coalesce. Article 26 is concerned with group or collective right to religion. Article 26 is not a standalone provision. Article 26, despite not being subject to 25, would have to be harmonized with 25(2)(b).
I think
This is the Devaru.
your contention comes in page 11.
Yes, I'm just pointing out that these are the 4 structures.
Yes, that's what you are relying on.
Yes, that's right. I have a problem, Lord, with this first structure of Devaru, lords.
First, second.
I have pointed out the fallacy.
First, second and third, you do not agree.
Yes, sir.
You are disagreeing. You are agreeing only with the fourth structure.
The reason is, my lord, that to harmonize states' power, enabling power to make a law with a fundamental right is basically
Correct.
inherently
Yeah.
incorrect concept, my lords. So unless, my lord, we say that there is some element of the fundamental right to religion, even with regard to religious denomination, which is embedded in 25(1), 25(2)(b), my lord, cannot operate. To bring it through a backdoor of harmonization, because please see, my lord, this is significant because if you apply this harmonization principle between a fundamental right and a enabling lawmaking power, then kindly apply it to 19(1)(a), my lords. Then we are, my lord, harmonizing with 19(2). What is the correct approach is that if a law is made by the legislature, it will be tested whether, my lord, it is related to the head, whether it is reasonable, not disproportionate, not manifestly arbitrary. So there's no question of harmonizing states' power to make law with the fundamental right.
The way that actually helps you.
Yes.
Supposing the law which has been enacted under 25(2)(b), you can still go into 25(1) and say it affects my right. To that extent, actually, it helps you.
So for religious denomination, no, I will be invoking as a religious denomination 26. My case is, my respectful submission is that the religious denomination has been carved out and given additional special rights under 26. 26(b) particularly.
Very good.
So when confronted with 26(b), how does we bring in and harmonize the two? It's much better to achieve the result by the structure of mandatory injunction of 17, etc., and morality.
It is on the premise that we agree with you that 26 is a standalone.
No, it may not be standalone.
So far as application of 25(2)(b) is concerned.
May I say this, my lord, with respects that no provision in the Constitution is standalone. Ultimately, all provisions taken together make the constitutional system. So merely by saying 26.
Page 13, serial number 7, you also said 26 is not standalone.
Yes. I am saying that nothing emerges from this expression, my lord, that it is standalone or not a standalone. Ultimately, one has to see, my lord, how do we limit it? What are the limitations on 26(b)? Can we bring in 25(2)(b) by a roundabout manner way or by harmonizing 26(b) with that? That's my humble submission.
That time the particular legislation has to be seen.
That's
Then whether it is really encroaching upon 26(b) or it is an instance of social reform has to be weighed. That is where the harmonization comes.
So
whether it is an instance of social reform under the Act or
that's right.
in the guise of
Suggesting what I am respectfully suggesting for
we have to balance.
well, the question of harmonizing doesn't arise, my lords. They are not co-equal fundamental. Harmonization will arise, for example, my lord, if 29 and 30 my lord, have to be balanced. 29 says, my lord, that nobody will be restricted from admission. 30, so then two fundamental rights you can balance. But fundamental right and legislation, harmonization doesn't come in when a law is made. The lordship will judge, my lord, is it reasonable or not? Is it following up 26(b) or not? So that's a different kind of a approach and test. Not,
Gopal and Mr. Dhawan has also argued
Yes,
that
yes.
harmonizing question arises only when you perceive some conflict.
yes.
There is no conflict, where is the question of harmonizing?
And to say, because Devaru says there are two co-equal provisions. So lawmaking and fundamental right to make it co-equal and then start harmonizing. So that logic, Devaru is correct on principle when it says that the law made in that case was good. Because it was a public temple open to everybody and therefore, and 17 is there and therefore that logic part is correct. But when it tries to bring it through this route and say co-equal rights and then harmonize the two, that I submit is fallacious.
By considering the validity of that particular law, there has to be a consideration of 25(2) and 26(b). There the harmonization comes.
So
In
Lordship
the
will,
context of considering both the articles. You can't
believe-
ignore 26(b) while consider, and only say it is social reform and therefore uphold it.
Lordship will,
At the same time, you can't ignore 25(b) and say, I will consider only 26(b) and I will strike it down.
so that
Harmony is in the
so
consideration,
that's a question of proportionality, my lords.
consideration.
Is it excessive? That will be the question, my lord. Once a law is there, it falls under the head, then the question will be of excessiveness. My lord. That's my humble submission.
Thank you, Mr. Dwivedi. One line if you want to say,
Just-
please.
just-
Yesterday,
Just one aspect, my lord, I'll not read it. I have, my lords, at the end, there was some effort to draw a limitation from the preamble, my lords. The preambular values. It was said, my lord, that limits Article 26B,
page 21.
which is at page
Yes, brother,
21.
he said no power.
Yes, and I have a lot from Keshwan and Bharti, I have quoted a lot from the various judgments
Yes, yes,
at page 22 and 23,
yes.
which they say you can use it only where there is some ambiguity in some provision to understand it, but not to impose. It's not a source of power.
Yes, sir.
It's not a limitation.
Thank you, Mr. Dwivedi. Thank you.
That's
Can you take your lordship to the table? Just that 25(2) begins with nothing in this article.
Yes.
Just that,
Yes,
because for the sake of completeness, my lord,
Yes, sir.
I'm very sorry to jump up. My bones don't permit it, my lord.
I will take 2 to 3 minutes to 5 minutes.
Huh?
3 to 5 minutes, I may be allowed.
1 minute only, please. 1 minute.
Minutes, 1 minute, it may not be over. I respectfully submit. It is on Article 290A. 290A, the disbursement of the funds from the monies from the consolidated funds minutes cannot be applied to Shabarimala because it is an unincorporated Devaswam. In that context, minutes, the two sections of the Travancore Devaswam Act, TCHRI Act, may kindly be seen. Minutes, the section 2,
Like, we will examine it. You can give it.
after lunch minutes.
We'll consider.
After lunch minutes only, 2 minutes only.
Yesterday, nobody turned up. We kept on, we were sitting till 5 o'clock. Now suddenly again, people have started.
Minutes,
Just one line only.
Yes. Let's one line. Let's, my
We will
submission,
examine.
3 minutes may be given.
We will consider it your note. You want to say something more?
Yes.
What do you want to say?
Because I could not be present yesterday because of my position. I was in the hospital.
Okay.
That is why I'm pleading.
So you must have said everything in the note.
Beg your pardon?
You are giving a supplementary note today.
Yeah, I'm giving a supplementary note.
Huh.
I'm giving the covenant entered into by the Maharaja of Travancore and the Maharaja of Cochin in the matter of governance of these temple under the guaranteeship of Government of India.
We will go through it.
Someone brought you a notice already yesterday. You were not there. Somebody has brought you a notice.
And section 30 of the TCHRI Act also
That
dealing with the
specifically agreed between them that
unin-
they should fund it.
unincorporated temples. And section 26(2)B, Lordship may kindly see, will not take away the character of this family temple, which falls under 26(B) of the Constitution. This is what I would like
He
to.
brought to our notice about this Article 298.
No,
Yes.
this Shraddha Deshmukh.
Can I hand over?
Yes, yes.
So on.
अरे
Yes.
लेते क्यों नहीं note?
I'm handing over.
Yes, we will examine it, Mr. Radha. We will consider it.
Thank you very much.
Yes, Mr. Doshi, one line.
One line, Manoj. Manoj, the only submission is, Manoj, we are for the community. This is the community of Tiruppan, Alavar, Amal community, which is a religious denomination, and the right is a pre-constitutional right, Manoj. The submission was made that this is not a pre-constitutional right, and therefore, Manoj, this right which comes from the Entry Protection Act, Manoj, from there the community has got the right. Now, Manoj, that right comes with a duty. And therefore, the duty is to ensure and protect, Milords, the sovereignty and the nature of the God which is there, or the deity which is sitting over there. That right has to be protected. Milords, in my note, I have also covered Keshwan and the Bharati, Milords, where Justice Sikri's 2 paras may be relevant.
All right, all right.
Not emphasizing more, Milords. My note.
All right,
is that.
thank you very much. Now
Right.
from the both sides, the arguments are over. Mr. Prameshwar, immediate after lunch, 2 o'clock.
Can we just enter a written submission, lordships can consider?
Yes, you can give any note that we will in the last Mr. Prameshwar.
I have given my note. I must apologize for the length of the note first. But I
We are
thought I
also
must.
sorry that we have curtailed your time.
Not at all, Millards. No, that's why I gave a lengthy note, Millards. I'm confident that your lordships will peruse that, Millards.
We'll permit
I
you
have,
to give, we'll permit you to give another one consolidated one, but whatever time is left.
my
now.
note is exhaustive, Millards, because I believe it takes care of the arguments of both sides.
That's right.
I have reflected on a number of questions that have come across from the bench over the last 1 month, Millards. That's why the note is lengthy, but I promise not to read the entire note, not to go through every section of the note. That assurance, your lordships will take it from me.
Hope we have not prepared our judgment.
Not at all, Millards. Not at all. Millards, that task is a very, but this subject, Millards, has complexities that I think this court has hardly faced till date on the questions. Millards, there are three ideas that permeate my note, Millards, and I am specifically employing these terms. First is spiritual identity. I have specifically not used the word religious identity. I have used the term spiritual identity. That's the first term you will see constantly in my submissions. Second one, your lordships will see is spiritual autonomy, spiritual identity, spiritual autonomy. Third one, which is a resultant of the first two, is spiritual diversity. These three elements are the elements that are the core of what your lordships are considering under Article 25 and 26. Spiritual identity, spiritual autonomy, spiritual diversity. All three dependent on each other, interdependent on each other. Added to that, is a phrase Justice Mukherjee uses in Shurur Mat, spiritual fraternity. And I believe that term, is a better term than the constitutional term denomination. The term is used multiple times, but kindly bear that in mind. Spiritual identity, spiritual autonomy, diversity, spiritual fraternity, and the last S of the 5 S's is social reform. And I believe, emphatically believe that Devaru was rightly decided. It showed that spiritual autonomy, diversity, and social reform can coexist together. And it is that balance, is the cornerstone of my submission. That your lordship's approach in my respectful submission also has to be that one can balance spiritual identity, autonomy, diversity, and at the same time, social reform can coexist. This is about 25 and 26. Much is being said about part 3, Millards. R.C. Cooper, 26 being an island, 25, 26 plus. On part 3, Millards, I have 3 submissions to make, Millards. Individuality of the rights have to be respected. Every right in part 3 has an individuality. 25 has an individuality, 26 has an individuality. Similarly, 21, 17, 23, 24, 14, all of them have an individuality. So individuality of rights have to be respected. 2, when your lordships respect the individuality of rights, Millards, your lordships must not ignore the interconnection between the rights. Because I have consciously not used the term independence of the rights. I have used the term individuality of the rights, and I have used the term interconnection between the rights. And in saying so, Millards, interconnection between rights, I am not saying all rights merge into one. That is the effect of some of the doctrines we see in the last 15 years. That one right is read into the other right is then superimposed on the third. Constitutional morality being an example. That you pick and choose elements of different rights and then read it into that third right. I am not saying that. Individuality of the rights has to be respected. Interconnection between rights have to be respected, Millards. And the third and the most important, according to me, Millards, integrity of part 3 as a whole has to be respected. Because there are 3 submissions that have been made, Millards, to me, which affects the integrity of part 3 of the Constitution. First, the decision in Association for Democratic Reform says there is a hierarchy of rights. And this was alluded to by Mr. Subramaniam in the morning, Millards, that there is a hierarchy of rights, Millards. In my respectful submission, there is no concept of hierarchy of rights in part 3. That's why the integrity of part 3 is important. Number 2, Millards, certain rights are categorized as horizontal, certain rights are categorized as vertical. That strict classification is also not there. Every right is to be employed by your lordships when your lordships exercise power of judicial review. It depends on facts and circumstances of every case. Your lordships will not say, Millards, with all due respect, that when we exercise jurisdiction, judicial review under 25 or 26 or under 14 or 19, we will not employ some other part of part 3. The entire array of fundamental rights is available to your lordships. How your lordships use that entire array of fundamental rights, that entire bouquet of fundamental rights, is for your lordships to determine on a case-to-case basis. Individuality, interconnection, integrity of part. I also do not believe, Milos, the integrity of the part 3 calls for a classification rights as being political, social liberties, economic, etc. Milos. Because again, that doesn't see the interconnection between the rights. So if your lordships look at part 3 as one whole, in my respectful submission, there cannot be an argument, my lord, that says that given the circumstances, your lordships will not apply every one of the rights. Your lordships will say, yes, in matters concerning 25 and 26, perhaps 14 has limited blame. Your lordships will say, yes, when it comes to 25 and 26, 21 as a limited blame. Some submission was made in the morning saying rationality. I completely disagree with the view that the other side has given, saying that rationality must be something that is read into 25, 26. No, Millards. There is a huge difference between faith, belief, and rationality. The moment you bring in rationality, Millards, 25, 26 goes out of the constitution, with all due respect. But your lordships at the same time will not say that other fundamental rights will not apply to a case under 25 and 26, Millards. Female genital mutilation being the best example. If your lordships are called in exigent circumstances that it is needed to preserve the liberty or the bodily integrity of people, doesn't matter whether it is claimed as a right under 25 and 26, your lordships will employ Article 21. Your lordships will employ Article 14. Your lordships will employ Article 17. Your lordships will ensure that people have access to religious institutions. Your lordships. But at the same time, that does not mean it will come at the cost of 25, 26. My submissions on this are like this, Millards. Mr. Subramaniam said in the morning, Millards, that the way your lordships use rationality, reason, etc. in the 14, 19, 21 test, Millards, does not apply to 25, 26. I tend to agree with that. Because the way your lordships, if I can use a better, different expression, Millards, I shouldn't say better, a different expression, Millards, the way the constitution seeks to distribute spiritual resources under 25 is distinct from the way it seeks to distribute material resources under 14, 19, 21. I hope that submission is clear. That is why that equality was inbuilt into 25. There cannot be a straitjacket application there, but the way the constitution treats religious and spiritual resources is different from the way the constitution treats material resources. And it is for that reason, Millards, that perhaps Mr. Subramaniam suggested that 14, 19, 21 do not have direct application. But in my respectful submission, if your lordships in a 9-judge combination were to say that 14, 19, 21 do not have any application at all, Millards, it freezes the law, Millards. And I would respectfully urge your lordships that when your lordships say in a 9-judge combination that 14, 19, 21 do not have any application to matters under 25, 26, Millards, the high courts are completely bound by this. But judges of this court are completely bound by a 9-judge judgment, Millards. Your lordships have all the tools in your arrows in your quiver, Millards, to balance the application of other fundamental rights to part to 25 and 26. But my respectful submission is, Millards, please do not exclude the application of other fundamental rights to part to matters concerning 25 and 26. Because, Millards, we do not know what judicial circumstances will come before your lordships, legal circumstances will come before your lordships, where your lordships may have to employ one of these rights. So build in that safeguards. Your lordships have already suggested one safeguard. Your lordship said, yes, we will look at who is coming. What is his locus standi? What is the cause of action? That is one safeguard your lordships can build in. The other circumstance your lordships can build in while using 25, 26 and other fundamental rights is matters which are a pure denominational conflict of what is the actual ritual to be used when there are two denominations. Yes, no question of 14, 19, 21. That is for a suit. That is a denominational, inter-se denominational conflict. If it is a question of control over institution by two sets of denomination, two sets of believers, again, your lordships may not trigger the judicial review route. Third, succession to offices, of whether there is somebody, religious officer, succession. If your lordships build in these safeguards, my lords, I think it is in the interest of constitutional interpretation that part 3 must receive its full play. How your lordships tailor that, my lords, is part of that balancing exercise.
As long as it has nexus to religion,
So long.
that is a safeguard.
Yes,
Subject
my
to
lords.
part 3 means not what Dr. Dhawan said, something to do with the political right which we are concerned. So long as it has some nexus to what is guaranteed under Article 25(1), it can be considered.
My lords,
If there's no nexus, that is how you have to balance.
I agree, my lords. That's why I said, my lords, the way the Constitution treats material resources is very different from how the Constitution treats belief, faith, conscience, my lords. My lords, and my lords, I've attempted in my note, my lords, to say that in the Indian context, Article 25, the right to religion, is not just the right to believe. Of course, it is the right to believe, my lords, but I would take it a step further. It is the right to seek. This submission is of some importance for the arguments I am placing today, my lords. Your lordships must create that constitutional space for a right to seek, of inquiry, of pursuit. The Indian religious traditions have always been a tradition of inquiry pursuit, not just dogma, not just belief. If your lordships read, my lords, the terms always used, my lords, it is an anveshanam, it's an anveshiki, it is payanam, it's a journey, it's a pursuit. If your lordships are able to create that constitutional space, saying that it is not just a right to belief that is important under Article 25-26, but also the perspective of a right to seek, to discover your true spiritual pursuit, then your lordships will then imply in your lordship's judgment that no practices are small or big. No practices are essential or unessential. No practices are core or penumbra. Because the biggest problem in Article 25-26 jurisprudence of the Supreme Court has been that it seeks to categorize certain practices as core, certain practices as essential, and certain practices as non-essential. It has two fallouts. One, it constricts the right to belief and the right to seek. It doesn't give the individual or the collective the freedom to explore. Because I would think, Milords, that the right to believe, the right to seek also encompasses within it the right to stumble, the right to doubt, the right to reaffirm. There's something similar to what Mr. Subramaniam said in the morning. So I have stated in my note, Milords, that your lordship's perspective on the right to belief under Article 25 must not just be a right to believe, but it must
how do you draw the line? See, it is the denomination, let us say, it is individual, both can claim in 25(1). Denomination can claim by a group of common belief, and individual can claim. Now, ultimately, it's a conflict between individual right vis-a-vis the denominational right. Whether this right can it be a factor to be decided by the Constitutional Court?
Milords, can I just because
It comes down to one's right as against the other's right.
Milords, can I just read out, because I think, Milords, it will be easier to save time on this aspect of, because I believe Justice Sundaresh's questions over the last 1 month have always been with the connection between Article 25, 26, whether 26 is bereft of any identity without 25, Milords. In my respectful submission, Milords, 26 has some identity. It is not merely the institutional identity that Dr. Dhawan seeks to give it, Milords. I think 26 as a doctrinal identity on its own, irrespective of whether the denomination has an institution or not, Milords, in the strict terms of the term, institution or organization, Milords, there is something more. Can I just read out those paragraphs, because I think it will save time, Milords. Would your lordships kindly see page 7 of my note?
Yes. D.
Page 7, Milords, para 20.
Yes.
The collective is not just the physical or temporal presence of a number of persons. Collective religious pursuit is the sum of inherited collective religious thoughts, writings, scriptures, practices, etc., which develops through time and results in the religious practice in the present. The individual in exercising the right under 25(1) does so inter alia by subscribing to this shared body of beliefs and practices that define the religious community. In this sense, the individual and the group are not conceptually distinct but mutually reinforcing. Collective and individual pursuits are not hierarchical. They inform and feed into each other. The meaningful exercise of individual religious freedom is therefore contingent upon the continued existence and protection of the institutional and collective structures within which such freedom is realized. Would your Lordship now turn overleaf page 9, Milords? Para 3. This is not to say that the collective identity of the fraternity only flows from the individual right under 25(1) and has no meaning on its own. To the contrary, the spiritual collective is specifically recognized and conferred with rights elevated to the status of fundamental rights. The collective of individual believers has its own identity, existence, and individuality. It is this individuality and identity that is the subject of protection under 26. This is important because it is not independence. It is the individuality of the right under 26. So, it's very easy to categorize that 26 is just a collection of individuals and the sum of all their 25 experiences is what features it. That's not true, because 26 develops an identity of its own, a organized religion, a organized spiritual pursuit, over the years develops an identity of its own. So it is not a question of 25 versus 26, because every person who is subscribing to a right under 25, who holds a right under 25, is equally partakes that character of 26. So when your Lordship says, that 25 is to be conflicted with 26, it's just not a conflict between 25, 26. It's a 25, 25 conflict and a 25, 26 conflict. Because not just the person who's seeking to dissent is conflicted with the religious denomination's rights under 26. It is other people's rights under 25 which are also subject to challenge when that person under Article 25 comes to court and says, no, these practices are bad, etc. So my respectful submission is, that your Lordship's reading of Article 25 and 26 must not collapse the identity of 26 into 25. But at the same time, your Lordships must preserve the individuality of 25 and 26. So 26 is not just institutional. 26 has doctrinal character. It has character in terms of faith. It has character in terms of the spiritual pursuit that are to be undertaken. Therefore, the relation between 25, 26 is not just the individual and the collective as an institution. It is that 26 as an identity of its own. Can I just come back to the first part of my submission, which is page 1, because I believe somewhere down the line, we have constricted the definition of religion. Your Lordship's notes, the word religion, the definition of the word religion would inform the word religious practice, affairs in matters of religion, and religious denomination. So kindly see para 2.
Yeah.
The meaning of the word religion controls the interpretation of the right. It informs the meaning of the terms religious practice, affairs in matters of religion, and religious denomination. At the same time, an attempt at defining the term religion with precision is constitutionally imprudent, especially because it risks being either overbroad or restrictive and is impossible to articulate. I have given in the first footnote, from 1868 to 2026, the US Supreme Court has been in vain attempting to define the term religion. And that is why I said, we must eschew this attempt to define religion. Language has proved insufficient to describe the true nature of religious and spiritual pursuits, which are polydimensional, non-linear, dynamic, and diverse. These conceptions cannot be situated within the framework of a scientific rationality, and therefore a juristic definition of religion with a catch-all mandate would be unduly reductive and contrary to the constitutional intent to guarantee the protection of religious freedom. The High Court of Bombay in Ratilal Panachand Gandhi versus State of Bombay held that religion ought to be viewed in a narrow etymological sense. This court, in Shirur Math rightly rejected this formulation of the High Court, noting specifically that in the Indian context, religion cannot be expressed in a narrow sense. A measure of definitional restraint is therefore necessary, for it is this openness that creates and preserves the constitutional space within which the right can meaningfully operate. An unduly restrictive definition risks contracting this constitutional space, excluding sincere expressions of faith and practice from protection of 25. The right must be read in the widest possible manner and its restriction in the narrowest possible manner. The term religion must therefore be understood descriptively rather than definitionally. Religion and pursuit of religion is polydimensional. In the Indian perspective, the religion is not just the relation with one's creator. It is not necessarily theistic. It is not necessarily a system of beliefs or doctrine. And it is not necessarily dogma and practices. It is not merely a set of ethical rules or rituals and observances for the followers, ceremonies and modes of worship, though it could be any or a combination of all of them. In other words, religion is inherently experiential, manifesting not only in thought, but sometimes in conduct, ritual, and collective participation. This understanding is particularly significant in the Indian context, where religion is often expressed through diverse, non-doctrinal, and practice-oriented forms. In the Indian perspective, an understanding of religion requires a recognition of the interconnectedness between doctrine, ritual, theory, practice, and various other forms of spiritual pursuits. Why have I said this in para 5 minutes? But because this is Nagatna indicated in the morning session, that you will necessarily not find a doctrinal set of beliefs for a tribal religion. You will not find it documented. You may not find it mentioned in text. Why tribal religion? Some of our Grama Devatas, etc., in the villages, you will not be able to trace that, oh, this belongs to a Puranic era or this belongs to the Vedic era. For example, your Lordship knows in South Canara, Bangalore districts, Panjuruli, there are many Devatas. That is equally an important part of religious faith worship. In Tamil Nadu, you have Grama Devatas, Periya Karupasamy, etc., etc., which equally require the constitution's protection.
In Himachal Pradesh.
Himachal Pradesh,
Prominence.
The Bishnois in Rajasthan, for example, from where the Chipko movement originated. For them, if you ask them, please prove doctrinally that the trees and the animals surrounding your community are part of your spiritual existence, they will not be able to prove it doctrinally. That is why I said religion is part shared experience. Because the way in which this court has evolved, why I'm at pains to point this out, because this submission has some connection with the submission on ERP, which I will be making. Because what ERP tries to do, it tries to privilege certain practices over others. That's number one. Plus, the easiest critique of the ERP doctrine is that one, that it is not constitutionally there in the text. Number two, the criticism that is
elitist in a way.
It is very elitist. It is extremely elitist in a way, because an individual's pursuit, of spiritual pursuit is as much a part of his Article 21 as much it is part of 25. And there lies the interconnection between 25 and 21. You remove my religious practice, you remove my religious pursuit, my spiritual pursuit, to that extent, you're also denting my identity under Article 21. There is one more connection, 21, 25, and the right to culture under 29. Can I just trouble your lordships with reading 29 for a minute? If your lordships kindly sees Article 29.
All coming from liberty ultimately. 51 is also liberty. In the preamble itself, it says liberty of thought, expression, belief, faith, and worship.
Yes, Milad, that's why I'm saying, the preamble makes that connection very, very clear, that 21 and 25 are not divorced from each other. So when you privilege, as my Lord Justice Sundaresh said, when you say certain practices are elitist, non-elitist, Milad, to that extent, my identity under 21 is undercut completely. What you're then saying is that your spiritual pursuits are not worthy of constitutional protection. Therefore, this constitution and this court will not guarantee you protection under 25, 26. I believe, Milords, that is the doctrinal flaw in the doctrine of ERP. Not just the fact that the courts are ill-equipped to get into whether a practice is essential or not. Of course, that is one part. But more fundamentally, Milords, The ERP doctrine fails because it creates this hierarchy. This hierarchy is a problem. It privileges certain practices.
It can be used only as a tool to say, look, this practice is so essentially or essential religious practice. It is not secular.
Let's,
So as to keep it, but you can't say it is not an essential religious practice, therefore I won't
that's
protect
right.
it.
I'll come to that.
Be the
Let's, I'll come back to that. Let's, I'll come back to that.
it is an aid,
I understand that, because I come back
not
to
a test.
I come back to that, Milas. Your lordships are right, Milas, because Dr. Ambedkar also wanted essentially to be used in contradistinction to secular.
Yes.
What was a test for differentiating between secular and religious became a test for determining what is better in a religious. So what was a test for judging the nature of an activity became a test for judging the nature of religion. I hope I have made myself clear, Milas. Dr. Ambedkar said, Milas, this we will, Dr. Ambedkar said, look at the activity, see whether it is essentially religious. If it is essentially religious, leave it. It is out of state regulation. From essentiality of activity, the code made it essentiality of religion. That distance that this court covered over the last 75 years, Milas, is a problematic part. But I'm just going back to Article 29 for a minute, Milas. Kindly see what 29 says. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. Because my submission is 21, 25, 29 must be read together.
28, 29?
21, 25, 26, and 29.
29.
29. There are entire spaces in culture, Milos, which are influenced by religious thought. There are entire spaces in language, literature that are influenced by religious thought. Milos, some of the best literature and culture has come out of the Bhakti traditions, both in the north and in the south. How can we forget the contribution of the Bhakti traditions in the north and the south?
This is where you will have to read it along with the fundamental duties. 51A, subarticle F.
Yes, but I have one concern in fundamental duties. One of the clauses in 51A says you must have rationality and scientific temper. I have some concern there, Milot. So when I make my submissions on fundamental duties, I will come to that. Part 3, Part 4, yes, but if your lordships, because your lordships have the constitution in your hand, Milot, kindly mark that clause also. 51A.
Yep.
To value and preserve the rich heritage of our composite culture, but H to me is a little problematic there. To develop scientific temper, humanism, and the spirit of inquiry and reform.
Independent of, yep.
Yes.
No,
Yes.
there I think the meaning in fundamental duties is not to, give importance to superstition. That's what Justice Rajendra Katkar also tried to say. Differentiate between a religious practice and superstition.
Because one man's religion is superstition for the other.
Correct. That is where we have to see.
One man's, plus that line is a very thin line. Again, Dr. Dhawan argued that. He said, you have the right to believe in superstition. It is certain practices that arise out of that are the matter of social reform. I hope that line is very clear. Dr. Dhawan argued it quite well, Milot. I thought that formulation was well put. He said, Justice Gajendra Katkar was wrong when he said you don't have a right to have superstitious beliefs, because that line between religion and superstition, you ask a rational man, he will say the entirety of religion is superstition. If you ask a rational person, a person who doesn't believe in religion, he will say the entirety of religion is superstition. So you have a right to believe in superstition. I wouldn't put right to believe in superstition, but the belief of superstition can't be taken away, Milos. But its practices, because they are abhorrent to the society, Milos, that's why your lordships have those legislations under Article 25(2)(b).
Yes.
So the distinction between superstition and religion, Milos, is a very, very, very thin line, Milos, in my respectful submission. Milos, the point I was trying to make using 29 was also this. Language, scripts, culture, all are at some point, Milos knows the Tamil Bhakti tradition, even the Kabir tradition in North India contributed so much to language, Hindi and Tamil. Similarly, the word used is any section of the citizens, because it was argued from the other side that the constitution only recognizes one unit, the individual. It doesn't recognize group units. Dr. Dhawan has given a list of sections and groups which are constitutionally protected. That the constitution doesn't just seek to protect the individual as a unit, but confers group rights also. 29 is one example. And see the word employed in 29. Again, when I make my submission on denomination, because I will connect this to that. Any section of the citizens having a distinct, this distinctiveness is not there in religious denomination, because the courts have imposed this requirement of distinct. Kindly see that having a distinct language, script or culture. I can straight away say this distinctiveness, Justice Deepak Mishra, Chief Justice Deepak Mishra in Shabrimala says that you do not have anything distinctive in your practice. You have nothing novel to show within Hinduism. He uses both the tests, distinctiveness and novelty. Justice Nariman employs only distinctiveness. Justice Malhotra also says that there could be some elements of distinctiveness, but that according to me is incorrect in my respectful submission, because when the constitution wanted to use and employ distinct, it did in Article 29. It did in Article 29.
Yes.
The word freely employed in Article 25, according to me, gives us the depth of the protection of 25. The word employed is freely. There is only one other part in the Constitution, one other fundamental right which says there is a right to a freedom. There are only two provisions subject to correction in the Constitution which guarantees a right to a freedom. Article 19(1)(a) and the right to religion. These are the only two phrases, fundamental rights, which says you have a right to a freedom. You have a right to form association. You have a right to do trade and business, but you have a right to freedom of speech. You have a right to freely profess and practice and propagate your religion. Freely, therefore, gives the depth of the right, that you will not be skimmed off saying your practices are essential, non-essential. Your denominational status will not be dependent on what kind of practices you undertake or whether those are essential or non-essential. That's why, my lord, the argument on the definition of religion being a descriptive one, not a definitional one, the approach to religion, my lords, as descriptive and not being definitional, has a bearing on ERP. It also has a bearing on how your lordships look at denomination. Because if your lordships privilege certain practices, those group which do not practice those practices, milords, they will not get denominational status. I hope the line is drawn between the your lordships are able to see the interconnection between how your lordships are going to understand religion, how it will have an impact on ERP and the essential practices doctrine, and also on the definition of a denomination itself. Because if you start looking for distinctiveness, or you start looking for textual authority on whether this amounts to a denomination or not, if you are going to look at novelty, etc., to that extent, the group is also denied of protection under 26. So the way your lordships comprehend the term religion as a direct bearing on ERP, it has a direct bearing also on denomination. Because your lordships are not looking at individual cases, but temple entry is one that is required to be answered because the constitutional text itself employs the term that Hindu institutions of a public character, must be open to all in terms of the enabling provision under 25(2)(b). Plus, therefore, I have prepared a separate section on temple entry. That's at page 62. Milos, and I believe, Milos, some of the principles I've attempted to formulate at page 62 may also apply to other religious institutions, not just limiting itself to the Hindu religion. Milos, one of the criticisms of Devaru, Milos, has been that it attempts to balance Article 26, which is a constitutional right, with an enabling provision under Article 25(2)(b). My respectful submission, Milos, is that the right to temple entry for a believer is a right guaranteed under 25(1). Therefore, when Devaru attempts to balance 25 and 26, it seeks to balance the right of temple entry under 25(1) and the right of the denomination under 26. I must straight away say, my lords, that the right to entry under 25(1) into an Hindu temple is not an absolute one. There are caveats, my lord. Shall I just place them in seriatim? My lords, in part A of page 62, my lords, I have given your lordships the history of temple entry proclamation, my lords. Milords, I heard some arguments on the other side, Milords, what was the nature of the temple entry proclamation in the Travancore kingdom, Milords. But one thing is clear, and I am quoting Mahatma Gandhi here. Whatever may be the cause, the fact of the proclamation, page 64, Milords, whatever may be the cause, the fact of the proclamation being given effect to by an overwhelming number of Savarnas and being freely availed by all of Avarnas stands out as a miracle. Milords, why do I seek to protect temple entry under 25(1), Milords? Because I am imploring your lordships, I am not taking your lordships to the entirety of the material that I have compiled there. Temple entry is a matter of struggle. It is after a long battle, Milords, that people were given access to temples. If your lordships are only to situate it in 25(2)(b), which is merely an enabling power, Milords, it does disservice to the entire struggle of temple entry, Milords, that we have seen over the last 1 century. If your lordship sees, Milords, more than legal arguments, Milords, only examples can work. If your lordships have a Kanakadasa or a Nandanar in your lordship's mind, Milords, then your lordships will know how important it is to have temple entry so far as Hindus are concerned, because it is one of the most outstanding reformist actions of modern India, so far as temple entry is concerned. I'll come to what are the caveats on absolute entry. There's no question of an absolute entry, but what are the caveats that are on temple entry, Milords? But your lordships must recognize the struggle that went through for achieving temple entry in this country, Milords, and your lordships must accord it protection under Article 25(1), irrespective of caste, descent, birth.
It's like an access to worship. You say access to justice.
It is
access.
I couldn't have put it better.
Access to worship or access to practice religion.
Absolutely, Milords. I couldn't have put to your lordships create. Milords, two things must be borne in mind, Milords. Pre-constitutional legislations on temple entry, Milords, fell into two categories. I'm not reading it out, Milords, because I want to cover some more topics before I finish. Milords, I'm not reading it out. Pre-constitutional legislations in temple entry fell into two categories. One assured temple entry for the depressed classes. Your lordships will kindly note that. Certain states enacted legislation saying, quote unquote, depressed classes will have access to temples. Some states use the term Harijans, so it was limited. Post-independence, Milords, during 1948 and 1949, before the constitution came into force, Milords, number of states amended temple entry laws and said all castes will be entitled to temple entry. And that is a very, all sections of Hindus, all sections of Hindus will be given temple entry. And that is very crucial, because the argument this side has been that 25 is there, 17 ensures temple entry. 17 only protects one group. The point is that irrespective of caste or creed, Milords, caste or descent, all Hindus must have access to temples under 25(1). That is very crucial, because if your lordships hold that because of 17, 25(2)(b) will stand, Milords, it is only one part of Hindus who will get that access. If you are a believer, It doesn't matter what family you came from, doesn't matter what caste you came from, Milords, you have a right to enter a Hindu temple. And that entry is protected under 25(1). The enabling provision was because the constitution makers wanted to remind the legislature that this is a solemn duty you have. The enabling provision was also there because by the time the constitution came into force, Milords, there were n number of statutes which had protected temple entry. And the term employed in each of those, kindly know, I've given a list of all those sections also in my note, Milords, of different enactments. It says, in the like manner and to the like extent as any other Hindu. That is the term employed. It is not merely access into the compound of the temple. Dr. Singhvi said, Milords, 25(2)(b) gets you into the compound of the temple, and after that, the denomination rights take over. With all due respect, Milords, that's not true. Kindly see the words employed in each of those, including the 1955 Civil Rights Act, which was the Untouchability Abolition Act, Milords. The phrase used is, in the like manner and to the like extent as any other Hindu of whatsoever section or class may so enter, worship, pray, and perform. Therefore, Milords, the 25(1) right is not just a right of entry, it's a right to enter, worship, pray, perform. If it is a right to enter, worship, pray, or perform, Milords, it is available to a believer and a believer alone. That is the most important part. Every other person who comes in, Milords, is because of permissive entry. There the denomination has a right, or the temple authorities have a right to exclude entry. If you are a believer, you can walk in. And that right, Milords, because after 75 years, Milords, we cannot say that the temple entry movement in India survives because of the enabling provision under Article 25(2)(b). For example, today, Milords, in Karnataka, and I have cross-checked this multiple times, there is no legislation which says there is a right of temple entry. The Mysore Act was repealed. The Madras Act, which was applied to certain portions of Karnataka, that also stood repealed. So there are states, Milords, I have given a list of states in my note also, where there are no temple entry legislations.
You can read it under Article 25(1).
Yes, Milords, that's my submission. That the right to temple entry is available under 25(1) for every believer, irrespective of which denomination he might otherwise subscribe to or not. I hope I've made myself clear on 25(1), Milords. It is not based on denomination. It is not based on caste. It is not based on descent. If there is one qualification for temple entry under 25, Milords, 25(1), it is the status of a believer. Look, there are three conditions which must coalesce for the right of temple entry, Milords: the believer, the belief, and the object of belief. All three are important. The believer doesn't exist in isolation from the object of belief. His belief is paramount because his belief is the only thing that connects the believer, his or her, Milords, sorry. It is the belief that connects the believer to the object of belief. If you remove any one of these three essentials, Milords, temple entry fails.
But in the case of Sabrimala, the situation is to the contrary. A believer cannot enter between 10 to 50 years.
Milords,
It's a contrary situation then.
Milords, that's why I said, Milords, I'm not addressing on the individual.
Just keep that in mind.
That's right, Milords. That's why I said three principles.
Giving access to everybody is one aspect. There, it is the denial of access between 10 to 50, which is questioned. Insofar as a believer is concerned, there's no problem. But who is questioning becomes a...
That your lordships, I understand, Milords. That your lordships will take care when your lordships are seized with the Sabrimala matter, Milords. But as a matter of principle, the right under 25(1) of entry into a temple, irrespective of caste and birth, must be recognized. And if those three conditions coalesce, belief, believer, object of belief, not one can be missed out of all three. According to me, my lords, this balances out 25-26. Because what is it, my lords? The object of belief is not one person's individual property. The object of belief, my lords, it is the collective's manifestation. A deity, my lords, in other words, my lords, is the collective manifestation of what the 26, the Article 26 group or the Article 26 collective says the deity is. The deity has no independent existence in that sense, my lords. In a number of written submissions I have seen, my lords, deity is a person protected under the Constitution, under fundamental rights, my lords. That's not so. A deity cannot be subjected to the Constitution merely because, my lords, you're then subjecting it to a rational document. I will have to prove the existence of a deity. If I have to come to court, I will have to prove that the deity is a person and that in fact a deity is there. And that is completely violative of my freedom under Article 25. A deity exists in belief. The characteristics of a deity, the deity exists in belief. The deity is the manifestation of the believers. Whatever rights these people are claiming, Milots, as the rights of the deity is nothing but the manifestation of the belief under 25, read with 26. If your lordships bring the deity within 25 and 26 and confer the deity rights, my lords, it leads to a very problematic situation where somebody could similarly argue that if the deity is capable of having rights under Article 25, 26, the deity must also have duties under Article 51A. My respectful submission, Millets, we have had enough number of gods come to this court, Millets. The gods must and the deities must be kept separate. What your lordships will see, appreciate, and also decide is what is the belief of the people who have manifested their belief in the form of a deity.
See, in other words, you can put it this way. Once you have the belief of pertaining to a believer, and then the object of belief is the same, he intrinsically, by that belief of the believer, he becomes part of the denomination. Therefore, nobody can stop him.
That's why I said all three must coexist.
That's good.
Believer, belief, objective belief. Because your lordships can employ perhaps the same test for a mosque also. Because what your lordships are essentially saying is, it is not unregulated access to a temple or a mosque that is protected under 25(1). If there is a belief, that belief is manifested in the form of the rights of devotees or believers under Article 26. Your belief, the objective belief, and the right of believers under 26 all must align together. If that is the view your lordships take, lords, then 25-26 then becomes balanced. Lords, two things that Devaru showed us, lords. One, it showed us that a temple can be public and denomination at the same time. That's a wonderful balance that the court struck in Devaru. Secondly, Milords, Devaru also showed us, Milords, that denominational rights and social reform can coexist. And that is the balance, Milords, and I think Devaru is clearly 100 years ahead of its time, Milords. That it said that a temple founded for the benefit of a section of the Hindu community could transcend, become a public temple where people could enter into the temple as a matter of right. Therefore, it has a public character despite it having denominational status. Therefore, that finding of public temple and social reform go hand in hand. Two, how did Devaru balance the denominational right? It said that in certain circumstances, there could be an exclusion of all others during certain ceremonies, practices, etc. And that is how Devaru sought to balance the denominational right under 26 and the right to enter under 25. Viewed as a right under 25, one, the principal objection that Devaru sought to balance an enabling provision under 25(2)(b) and a constitutional right under 26 goes, because the primary objection has been, how do you balance a constitutional right under 26 and a legislative provision permitting entry? No, the balance that Devaru, that is why it says, the right under 25(2)(b). Devaru employs the expression right under 25(2)(b). 2B was only enabling, but the term employed is right under 25(2)(b). According to me, Milords, that right is a right traceable to 25(1). There is one more connection between 25 and Article 35, which I wish to point out, Your Lordship, because we are looking at temple entry laws, because there was one suggestion that nothing, Article 25(2), which says nothing in this article shall affect the operation of any existing law. And that law there, nothing in this article shall affect the operation of any existing law. That law there includes customs, traditions, practices, etc. Millards, that's not so in my respectful submission, Millards. Nothing in this article shall affect the operation of any existing law. Existing law must take color from Article 366, Clause 10, which very clearly says existing law is only legislative law. And that existing law, Millards, the examples are Sati Prohibition Act, Devadasi Abolition Act, any number of temple entry acts, Millards.
Which article you reading?
It was Article 25. Millards,
366(10).
I have dealt with this argument at page 87, Millards.
Any law made by an authority,
Any law, any legislative law, Millards.
anything made by an authority, it could be even in the form of a rule.
Rule, yes, Millards. That's right. It is statutory. It must have statutory flavor. It must have statutory flavor. It is not protecting customs, etc. Because if it protects customs, traditions, etc., practices, etc., Millards, then the entire purpose of social reform is lost. Millards, why is it important? Millards, kindly see 35 for a minute, Millards. Article 35.
Yes.
Legislation to give effect to the provisions of this part, notwithstanding anything in this constitution, Parliament shall have, and the legislature of a state shall not have the power to make laws with respect to any of the matters which under clause 3 of 16, 3 of 32, Article 33 and Article 34 may be provided for by law made by Parliament, and for prescribing punishment for those acts which are declared to be offences under this part. And Parliament shall, as soon as may be after the commencement of this constitution, make laws for prescribing punishment for the acts referred to in subclause 2. B. Any law in force immediately before the commencement of this constitution in the territory of India with respect to any of the matters referred to in subclause 1 of clause A, or providing for punishment for any act referred to in subclause 2 of that clause, shall, subject to the terms thereof and to any adaptations and modifications that may be made therein under 372, continue in force until altered or repealed or amended by Parliament. My lords, what 35 seeks to protect is pre-constitutional laws which had criminalized those acts which are sought to be criminalized by the constitution itself. It doesn't protect the right of entry as such. I hope I've made myself clear. In the context of a temple entry legislation, Billots, there were two provisions in every temple entry act. One, it gave all sections of Hindus the right to enter a temple. Two, prohibited, criminalized the act of prohibition from temple entry. What is saved under 35 is only the criminal sections. The right is actually saved under 25(2), which says nothing in this article shall affect laws which provide for social reform. B, kindly see B once again. Any law in force immediately before the commencement of this constitution in the territory of India with respect to any of the matters referred to in subclause 1 of clause A, we are not concerned with that, Millards, or providing for punishment for any act referred to in clause 2, which includes untouchability, etc. Only the punishment portions are saved under Article 35. How is the right to enter a temple saved under 25, Millards? Under the constitution, the temple entry laws between 1945 and 1950 are all protected because Article 25(2), which says nothing in this shall apply to laws which provide for social reform. 2, nothing in this article shall affect the operation of any existing law. So 35 seeks to protect criminalization of untouchability, but the right to actually enter the temple is protected under 25(2). So therefore, nothing in this does not mean it saves customs or traditions, etc. Nothing in this article purely saves only legislative enactments or rules which have a statutory flavor. Then your lordships may ask the question, where are the traditions, customs, and usages saved, Millards? All traditions and customs relating to religion are saved under 25(1), read with 26(b). all usages, customs, religious beliefs, not all customs and usages, those customs and usages which are part of religion and belief, my lords, as your lordships must give it an expansive meaning, all those are protected under 25(1) read with 26(b). So it is not necessary to go to Article 25(2) to protect customs. All customs are, and Milos, in my submission, Milos, I have given a list of all enactments, Milos, in Andhra, in Tamil Nadu, etc. Number of enactments are there where the respective temple legislations or endowment legislations itself specifically state that the temple shall be administered in accordance with the usages and customs of the denomination under Article 26. The savings clauses there, Milos, I have given a list of all those savings clauses. Page 78 and 79, if your lordships have a look, Milos. Yes, sorry, Mila.
That means you're saying if there is a custom or an entry, if there is a custom or usage prohibiting entry, that is saved under 25(1).
It is saved under 25(1). If somebody argues to the contrary that they are a believer and they must be given entry, my lords, then your lordships will take an appropriate call in the facts of that and facts and circumstances of that case, my lords. I hope your lordships have made myself clear. If somebody says there is a custom that prohibits entry, your lordships will have to balance that with the right of a believer to enter the temple. And then in that balancing exercise, your lordships will decide what trumps the other. Because it could be, it is not just...
Custom itself is recognized under the rule.
Yes, Milos, in all those enactments, kindly see 78 and 79, Milos.
TTP recognizes the custom which prohibits.
Milos, not just TTP, would your lordship kindly see 78, 79 for a minute, Milos?
Yes.
Section 12, Milos, of the AP Hindu Charitable and Hindu Religious Endowments Act 1987, I have quoted, Milos. The underlying portions are the portions which specifically save custom and usages. For example, lordships have it, Milos, page 78, 79. Para 54 at 79, the Bombay Public Trust Act has a specific provision on religious practice and usages of the trust. Similarly, the Kerala Hindu Places of Public Worship Authorization of Entry Act also says there is a proviso, para 55. Section 58 of the Karnataka Hindu Religious Endowments Act says the commissioner shall not interfere with and shall observe the custom, usages, ceremonies and practices. This is nothing but a statutory recognition of the fact that temple entry and customs go hand in hand. And that is the balance that Devaru attempted to balance. That's why.
Then where is social reform?
That's why I said social reform is very clearly there. And I'll come to that. If your social reform is there to the extent it does not completely denude the denomination of its rights. That's why Devaru said,
if problem in this. On the one hand, you want to uphold custom and usage. On the other hand, you are saying 25(1) is the right of entry, and 25(2) is an enabling provision. So you are going to uphold the custom, or you want to give importance to social reform.
That is the
right of entry is under 25(1), and the custom or usage prohibits. How do you balance? How do you balance?
The denomination will put up the defense under 26(b). And the person seeking entry will say it is their right under 25(1). Then the Devaru test will be employed, saying if you are giving full extent to the right of the believer under 25, your lordships will see whether there is anything meaningful left in the denomination's right under 26(b). In which case your lordships will permit entry. If your lordships want to see it from the denomination's perspective.
That's why they struck down rule 3B, which had said wherever there's a prohibition as per custom or usage, then as per custom and usage, such women cannot enter. That was there in rule 3B.
Yes,
That
Milords.
was questioned.
That was questioned, Milords. In Sabrimala, that was questioned. I'm saying in Devaru, the test formulated was,
Whatever is different.
Milords, Devaru is also a question of entry. Milords,
No custom or usage. We are considering it in the context of custom and usage.
Milords, that custom and usage will be used as a shield under 26B. Devaru also, the same custom and usage was used as a shield under 26B, and the denomination resisted temple entry. There the court said, we will look at the denomination's right under 26.2b, and after permitting entry, if nothing survives as the denomination rights, Milords, then entry is not absolute. Similarly, the court said in the balancing exercise, when we look at the entry as a right of a believer under Article 25(1), then we will look at the right of entry and we see if we allow entry, will there be something substantial that remains in the denomination's right under 26b? That's why the court said it excluded. Kindly bear in mind, Milords, in Devaru.
Little bit gray area, because if you say entry access to worship is under 25(1), there can't be a custom or usage contrary to 25(1). there.
Milords, that's why I said entry is
Because
not.
Article 13 itself says that
Milords, 25(1).
little bit of
Milords, 13 I'm coming to. 13 is very crucial. 25(1), the right of entry under 25(1) is applicable only if all three aspects are met, Milords. Believer, beliefs, and the object of beliefs. Because if your lordships don't situate right to entry into a temple under Article 25(1), then all sections of Hindus are only left at the mercy of an enabling legislation. That can't be, Milords, in my respectful submission, because of the struggle that has taken for people to achieve temple entry in this country.
we'll have to just balance this.
This 25, Milords,
We understand.
can I just?
Right of entry under 25(1), we understand.
We understand.
Yes.
Only difficulty is to bring it in the 25(1).
Yes.
Just think about it. You can bring it under 25(2). Though it only has enabling provision, which is an element of substantivity insofar as implement is concerned. 25(2)b, with respect to temple entry, it actually is a declaration recognizing the right of the believer to have an entry. It only facilitates the state to pass legislation, but actually it declares. It is only a formal expression by the state. That's a better way of putting it instead of tracing in 25(1). You can bring it into 25(2) itself.
Milords, whichever, Milords.
Because it's a social reform.
Milords,
It comes under this.
So long,
That would be a proper way to go.
so long your lordships say that there is a constitutional right to entry, Milords, it is sufficient. So long your lordships say, whether your lordships trace it under 25(1) or 25(2)b. Because I'm giving the example of Karnataka straight away.
Oh, there are.
Little bit tweaking will be required
Yes,
in
yes.
25(1).
As a matter of, these acts are all as a matter of reform. Otherwise, you see that usage, custom and usage will lose its sanctity.
Milords, the custom and usage.
Because it will be contrary to 25(1) right, which you are saying.
Milords,
Everybody has a right.
Milords,
They are advocating.
Milords, that's why I said, Milords, that custom and usage is something which will be used as a shield under 26b. And Devaru, page 81, I've just quoted that part. Milords, it's been read n number of times, your lordships, Milords. 26b, Devaru tries to balance exactly this. It says,
Just be stuck up in that Devaru case. They were the facts. We are as a principle. Dehors Devaru, what is the principle?
Milords, my respectful submission is this. I understand your lordship's perspective on that. Plus, my respectful submission is that we can't be put at the mercy of a legislation being there for claiming a right to temple entry, Milords. All castes, including Dalits, Harijans, scheduled castes, everyone has a right to enter the temple, and that right of entry into a temple, Milords, according to me, Milords, must be protected under 25. That is the only way your lordships will recognize the struggle that came into this right being in existence.
We understand that. But in the case of Sabrimala, the rule itself prohibited by recognizing custom and usage.
So your lordships will balance. So in Sabrimala, then the way your lordships will then perhaps formulate is whether the denomination's right is preserved by the rule, and if the rule is struck down, is the denomination put to a knot?
No need of a denomination there. It just says open all Hindu religious institutions of a public character. It may not be a denominational temple at all.
Milords, in that respect, Milords, I'll come to that denominational submission also. Milords, would your lordship kindly see page 85 for a minute, Milords?
85?
85, Milords.
Yes.
para 72. 73. 72. A deity is a collective manifestation of its worshippers. The existence of a deity, its characteristics, the form of the deity, the mode of worship, the ritual prescribed are all matters of religion. It is the external manifestation of the belief of the collective that gives the deity its form, attributes, and divine will. While the deity worshipped as an idol may be vested with juristic personality in the context of management of properties, the deity cannot be considered to be a legal person capable of bearing rights and duties. The deity cannot therefore be subject to a rational framework of factual and evidence-based inquiry under law. A person's right of entry to a temple under 25(1), read with 25(b), is not absolute. It must be viewed from three perspectives. The person seeking to assert the right must identify himself or herself as a Hindu believer. Entry to the temple must be sought for the purpose of worship of the deity, which is a collective manifestation of the belief of the devotees. This manifestation of religious belief in the deity is an expression of the rights protected under 25(1) and 26(b). The right of temple entry under 25(1) read with 25(2)(b) must be balanced and harmonized with denominational rights under 26 to manage their own affairs in matters of religion, which includes attributes and characteristics of a deity, modes of performance of worship and religious services, and the preservations of customs and extant usages. Your lordships have this task of balancing, and your lordships must confront that balancing task, Milords, in my respectful submission.
Next point.
Milords, on 13, Milords, Article 13, it has been argued that Narasimha Ali has been overruled, Milords. I have pointed out in my written submission, Milords, Chief Justice Chandrachud's opinion in Sabrimala, Milords, devotes a number of pages to the correctness of otherwise of Narasimha Ali, but makes a specific finding that we will leave it to an appropriate bench to examine the correctness of Narasimha Ali, Milords. In my respectful submission, is that page? Just take that up. My respectful submission, Milords, Article 13 has wider implications. It is not a question that has been formulated for this court's consideration in this bench, Milords. I say this with some amount of responsibility, Milords. If your lordships are to interpret 13 and say all customs which fall foul of will be covered under Article 13, and therefore if they fall foul of Part 3 of the Constitution, all such custom and practices will stand denuded of any legal sanction, Milords, has grave implications, Milords, on Schedule 5 and Schedule 6 of the Constitution, Milords. There's an entire amount of tribal indigenous jurisprudence, especially in the northeast in this country, Milords, which is customary in nature. Milords, my respectful submission, Milords, the question of Article 13 does not directly arise for consideration here, because if this side asserts customs and traditions as part of their right to religion, Milords, they are protected under 25-26. Therefore, we needn't go to 13. We needn't go to 13, Milords, because it has a wide-ranging implications on Article 13, Milords. I must also point out, Milords, this was also the view taken in Riju Prasad Sharma, which is the judgment concerning Khamakya. The court took the specific view that customs, traditions, etc. associated with religion and 25-26 are protected under 25-26, and therefore, Milords, we needn't get into Article 13 at all. That is my respectful submission so far as 13 is concerned. This part of my submission is addressed at page 87 to 90. 87, Milords, to 94.
No.
If your lordship see at 92, Milords, I have addressed this Article 13 argument, Milords.
92.
92, Milords. Can I just place para 20? I have extracted Riju Prasad Sharma, which is para 66 of Riju Prasad Sharma. On considering the relevant submissions and the relevant case laws, we are inclined to agree with the submissions on behalf of the respondents that Article 13(1) applies only such pre-constitution laws, including customs which are inconsistent with the provisions of Part 3 of the Constitution, and not to such religious customs and personal laws which are protected by fundamental rights under 25 and 26. So they made that clear distinction between customs which are saved or may be saved under or may not be saved under Article 13 and which are protected under 25-26. So Riju Prasad Sharma makes the difference. Kindly see the observation of Justice Chandrachud at para 21 in Sabrimala. The decision, para 397, I have extracted there, Milords, at page 93. The decision in Narasu is in immunizing uncodified personal law and construing the same as distinct from custom deserves detailed reconsideration in an appropriate case in the future. So, Milords, this question does not arise for two reasons, Milords. This was not personal law. What was argued in Sabrimala was not personal law. It was a question of temple entry, number one. Number two, Milords, custom never came to be directly questioned because there was anyway a rule. It was not a case where the custom was directly challenged. With all due respect, your lordships will have a different take on the facts of Shabrimala, but I must assist your lordships on the applicability of Article 13. There was a rule. It was that rule was put under challenge. Therefore, Milords, any observations on Article 13 to that extent, Milords, is completely arbiter. Because the occasion to examine a custom never arose in Shabrimala directly. There was a rule, that rule was challenged. So all you had to see was whether it was violative of fundamental rights or not. Irrespective of the outcome, I'm saying Article 13 was a clear arbiter so far as Shabrimala is concerned. Milords, on horizontality, Milords, I think I have made my submissions. Milords, it is not that there are certain provisions of Part 3 are horizontal, non-horizontal. My respectful submission, Milords, as a 9-judge bench, your lordships will keep the entire array of fundamental rights in your repository, Milords. If circumstances so demands, Milords, your lordships will deploy it. Because if 9 judges say that 21 doesn't apply to 25, 26, Milords, it is virtually in the nature of a prohibition. Therefore, I must address your lordships on the subjection clause under Article 25. Milords, 25 subjection clause, Milords, one view Mr. Subramaniam gave, Milords, was that that subjection clause is to enable the other people, when you claim a right under 25, it is to enable other people to exercise their rights under 25 or other parts of the Constitution, therefore a subjection clause. There is one or two more ways of looking at it. Two, Milords, 25 and religion is the only example in the Constitution where one of the prohibited indices under Article 15 and 16 becomes a right itself. Article 15, 16, etc. say, Milords, the state shall not discriminate on the basis of religion, sex, etc., etc. None of those indices which are mentioned in 15, 16 are themselves guaranteed as a right. I hope I have made myself clear here, Milords. 25 is the only place where one of the prohibited categories of discrimination under 15 and 16 itself becomes a right under 25. Because the constitutional man...
It's a basis of discrimination.
Yes, Milords. I'm saying...
Against the state. Here it is a religious freedom.
That's right. So my respectful submission is, Milord, that subjection clause may have been necessary for that purpose also. Because the Constitution doesn't say you have a right to race. The Constitution doesn't say you have a right to dissent, etc. It only says you have a right to religion. So those indices which are basis of discrimination, which are prohibited under 15, 16, Milords, religion is the only one among them which translates itself into a right later in part. Therefore, that subjection clause was necessary for that purpose. There is one more need for the subjection.
Article 21, you just now said to read Article 21 into Article 25.
Yes, Milords, it must be. No, I'm saying the subjection clause, Milords, therefore serves different purposes. It is not to create a hierarchy. It is not to subject 25 wholesale or 26 to the other provisions of that part. In my respectful submission, Milords, that subjection clause is one more utility. It is the only provision in Part 3 where social welfare and reform is specifically provided, notwithstanding the general power of the state to have power of the legislature to mandate social reform. Social reform must take color from other rights in Part 3 and also from Part 4. If the subjection clause was not there, Milords, it is open to challenge saying that social welfare for enabling a fundamental right under Part 3 is directly in conflict with the right under 25. So perhaps the subjection clause in 25 had one more purpose. That is to say that your social reform measures that the state undertakes under 25 2B, because this was a pointed question, my Lord Justice Sundar.
Instead of saying that, they could have said, notwithstanding anything contained in Article 25(1), the state is enabled to do this. You bring in all that Article 17, etc., etc., by way of enabling a legislation under 25(2).
Look, they have employed a clause which is very similar to a non-obstante clause because it says nothing in this article. That means, notwithstanding the fact that you have a right to religion under and belief under 25(1), social reform by the state is permissible. That social reform could take color from any of the fundamental rights. Devdasi reform is not just traceable to morality, not just traceable to 23 Milords. Devdasi abolition is a matter of 21. If female genital mutilation is being abolished by a legislation by the state in future, Milords, it will be taking into recourse not just health or morality under 25 and 26, but it will be affirming the woman's right under 21 of bodily integrity.
See,
So,
in other words, 25(2) is being read into 25(1).
yes, ma'am.
There is some kind of a restriction on 25(1).
Grateful,
Because 25(2) you read it
grateful,
in that expression.
grateful.
And the basis of the legislation would be the other fundamental rights, such
Grateful.
as Article
Grateful,
70.
grateful, my lords. Therefore, the subjection, sorry.
Go beyond that also. It might include directive principles also.
Yes, my lords. Part 3, Part 4. I have taken the stand in the note, my lords, that social reform, page 12 to 14, my lords.
The difficulty for us is, what is disturbing is that, how do we, which articles of part 3 we have to take it?
Yes.
Which article we have to leave it? But I think we leave it as such because, see, 25(1) does not, as my sister put, does not refer to any article in part 3. We merely say subject to part 3. So far, we can leave it at that, we can say subject to.
That's all I am asking
Yes,
your lordships to do, because it must,
Yeah, on a given factual, what you are saying, on a factual scenario, you test it, that's all.
your lordships may need it to
That's
protect somebody's life, dignity,
That's
etc. Your lordships may need it.
Provided those articles have a nexus to religion, not if they are dealing with something else.
Because there I respectfully,
Administrative law question, how is it? Those 14 to 23 must have something to do with religion. Then, subject to other parts of part 3 will apply. You have to read it like that, harmonize it.
because there, because I respectfully
See,
disagree.
if Article
Because I must
20
say,
preventive detention, if case is filed under Article 21, that has nothing to do with Article 25(1).
because it could be a simple matter of succession. It could be a matter of enforcing rights under 21 for the women. It could be,
One way of dealing
This
with
is
this.
the point which is really.
Just as you rightly said, social welfare and social reform is obviously on a very higher platform. Therefore, you can say the power of judicial review or determination of the court is only can be extended, we can say, with a larger bracket with respect to social reform and social welfare. That will solve the problem.
grateful, Millards.
That will solve the problem.
Grateful.
That's correct.
Your lordships, can I just put it a little differently?
Yes.
Primary responsibility for social welfare and reform lies with the legislature. That is a constitutional mandate. But that does not mean, my lords, that your lordships are not empowered in certain circumstances. My respectful submission is, please conserve that power explicitly in your lordship judgment. Because if 9 judges say that we have, the judicial role as I see it,
25(1) itself says so. Subject to part 3, therefore, how can we read it?
Great.
We can't read something into it, we can test.
as I see, the judicial role is not of a overzealous reformer.
You are
It is-
legally right that constitutional court can't give up its responsibility, that we can't surrender that.
Grateful,
It's not a question of power, it's a constitutional duty
Grateful.
on a constitutional court. We can't surrender that.
That's why I say, your lordship's judicial role is not of a overzealous reformer, nor is it of a passive onlooker. It is somewhere in the middle. If your lordships find that on the facts and circumstances, your lordships have to employ 21, etc., your lordships will do it, Millards.
Now 14 is being pressed into service in Sabribala.
Millards, then your lordships will evaluate that. Your lordships will evaluate 14, how it works with 25 and 26.
No, but when
Respond to
these
that.
questions, what is the meaning of subject to? We have to answer that.
That we will answer, huh?
Ah.
That our, that burden is passed on to us.
Millards, I'll go to the question. Millards, I also saw, Millards, during the submission, Millards, there was a lot of emphasis on the word conscience.
On what?
Conscience.
Huh.
Millards, there is a very, very broad definition of conscience and the purport of conscience given under 25. Millards, number of written submissions have taken that route. Millards, I want to strike only a note of caution that your lordships will get 210, Millards, on conscience. Your lordships kindly, and I just want to read it, Millards, because there is something that is deeply troubling on a very broad expanse of the term conscience in 25. Millards,
Yes.
210. Let me just read this, Millards. My Lord Justice Amanullah has it, Millards.
Yes.
Every judgment has a different meaning.
The content of conscience under article. The content of conscience under article. Because we asked Justice Amanullah because, like Justice Dhawan, Mr. Dhawan said, we are not able to see whether your lordships are. The screen blocks it completely. The content of conscience under 25(1), whether religious or moral, has been subjected to some debate by this court. The placement of conscience under the right to freedom of religion would indicate that the content of conscience under 25(1) extends to religious conscience. Indeed, in the first judgment examining this question, Justice Chinnapareddy's dissent in SP Mithil had arrived at this conclusion. In Puttaswamy, Justice Chalmeshwar also distinguished between religious conscience and conscience, please mark that term, Milas, areas other than religious beliefs,
What we are saying.
and founded only religious conscience in 25(1), while finding that conscience in general was available to an individual as part of their liberty under Article 21. Please keep this distinction in mind, because otherwise, if your lordships gives a very broad interpretation to the terms of conscience, then every moral value, every moral choice will be argued as one under 25. Kindly see what Justice Chalmeshwar said. Para 372 of Puttaswamy Millards, Constitution of India protects the liberty of all subjects, guaranteeing the freedom of conscience and the right to freely profess, practice and propagate religion. While the right to freely profess, practice and propagate religion may be a facet of free speech guaranteed under Article 19(1)(a), the freedom of belief or faith in any religion is a matter of conscience falling within the zone of purely private thought process and is an aspect of liberty. Please mark the next 3 lines. There are areas other than religious beliefs which form part of the individual's freedom of conscience and such political belief, etc., which form part of liberty under 21. The issue has been raised thrice more in Sabrimala, Supriyo, and the electoral bonds case. In Sabrimala, speaking for himself, Justice Chandrachud held that conscience in 25(1) is not merely religious, but is a cognitive process that elicits emotion and associations based on an individual's beliefs, rests only in individuals. He didn't qualify it, Milas, with all due respect, as a conscience that is associated with religion, to have a religion or not have a religion. It was given a wider import. In Supriyo, Justice Chandrachud, once again speaking for himself, found that conscience in 25(1) would extend to para 239. Some of the decisions, the moral quality of which they will judge, include the decisions on who their life partner will be and the manner in which they will build life together. Each individual is entitled to decide this for themselves in accordance with their conscience. So there, the right to find a partner for themselves in the context of a same-sex marriage was situated in Article 25. Because conscience was given a wider meaning. Kindly see.
Bit difficult to accept it.
Yes.
Because it's my duty to point out your lordships, because
See,
the way
to the extent, when you have a conscience, it may not partake the character of religion at that point of time. When you profess and practice, it is, you can say it's a starting point. It's a source. Conscience is a source. It develops into a religion. Because what you contemplate is in your mind. Over the, see, now then when you form and then practice professionally, it takes part as a character of religion. See, otherwise, you can't include political
conscience. I might conscientiously believe that Marxism is the only political theory that must be enforced.
Heading of that provision, Article 25.
Grateful. Marginal note.
Right to freedom of religion is the heading.
Grateful. Marginal note.
So conscience is with regard to profess, practice and propagate religion.
What of religion?
Grateful.
Religion, not political.
Relatable to religion.
Like they say, exercise conscience vote. Many a time they said you must exercise conscience vote.
Two expressions can't be divorced.
Yes.
They are relatable to each other.
Yes.
The religion will draw color from conscience and conscience will draw.
Not like saying you exercise conscience vote. Many a time we heard that.
So
whether they really do it or not is
that's right.
At that point of time, religion may not be born. The conscience is the foundation. It's based upon which religion can emanate.
Conscience is the unwritten constitution of religion.
That's
beautifully said.
That's right. Couldn't have put it. Look, my point was that there can't be a expansive reading of Constitution under Article 25 because it leads to problems. Because this opinion of Justice Chandrachud Millards didn't find favor with 3 other judges, which I've mentioned in para 3. And I just wanted to read one of the judges' finding at the footnote number 10, which I thought was important. Page 211, footnote number 10, which disagreed with the view that conscience is a larger conscience under 25. Well, Lordship says footnote number 10, Millards at page 211. Additionally, the opinion of the learned Chief Justice situates the right of choice of a partner and right to legal recognition of an abiding cohabitational relationship within 25 of the Constitution of India. Emphasis is placed on the term freedom of conscience, which is placed alongside the right to freely profess, practice, and propagate religion. The opinion situates in this freedom of conscience the right not only to judge the moral quality of one's action, but also to act upon it. If that were permissible under 25, then the textual enumeration of freedoms under 19 become redundant, since these freedoms can be claimed to be actions on the basis of one's moral judgment. I find it difficult to agree with such a reading of 25. This employment of the term conscience under 25 was taken one step further in the electoral bonds case. They said the right to give donations to political parties was also protected under 25. Would your lordship see that, man? Para 4.
No, Mr.
The majority judge.
Mr. Professor, the footnote 10 you wrote, it adds to the confusion. It now introduces the word moral. So now moral also comes into the moral quality of one's own action. Now morality also gets into.
Look, that moral quality comes from the Chief Justice's Chandrachud's opinion, page 211 at the top.
Now both.
I understand. That creates a complete confusion there on the term, on the implication of the term conscience in 25. It confounds different kinds of, according to the right view, Justice Chalmeshwar's view, one part of conscience is protected under 25. In terms of political beliefs, etc., it could be protected under 19, it could be protected under 21. But definitely those...
What is the Hindi word given in the Hindi text of the Constitution for conscience?
Antaratma.
No, not
Must be like
in the Antakaran. In all the oaths, prescribed under the Constitution, the Hindi word is Antakaran. Antakaran.
Antakaran is quite different.
Self-introspection. Something which originates from here, but come via head.
Can I just take 10 more minutes, Let's just
Yes.
I've promised my friend here also some 10-15 minutes.
You have 10 minutes. Don't worry.
Great. On denomination, one part of my argument on denomination was that a restrictive reading of the term denomination, completely prejudices the exercise of one's freedoms under Article 25, read with 26. In my respectful submission, the definition of the term denomination in Shirur Mutt using the Oxford Dictionary, must be only seen as indicative, not determinative of the issue of denomination. There are denominational practices in this country which can operate without a strict institution. There are denominational practices in this country which can operate without a strict organization, without a strict name. Shabrimala example is one of the best examples. They asked, what are the names that you have? They said, Ayyappan's is not a name that we recognize. 2, they asked, what is the distinctiveness? Again, that test of distinctiveness is a problem. 3, it was further inquired, do you have something novel in the practice, that completely denudes one's freedom of practice under 25, 26, if such restrictive tests are employed for denomination? It also has a problem when there are syncretic traditions. 2 syncretic traditions, I can say directly found in judicial pronouncement. One, courts in Tamil Nadu and Andhra were called upon to decide whether a Sai Baba temple is a Hindu temple or not. It was argued that people from all faiths visit a Sai Baba temple. One state, the High Court said, it is a Hindu temple. The other states, the High Court said it is not a Hindu temple. It's a charitable institution. So that is one. The other, is again a judgment from Madras High Court on the Ramana Maharshi, the temple where the remains of Ramana Maharshi are there. Question was whether the Matrabhuteshwar temple there was again a Hindu institution or not. Again, the court said, that people from various faiths come to pray at the temple, therefore it is not a Hindu. The point being, the determinative factor on a denominational institution cannot necessarily be as to who comes there. Your lordships will have to give it a broader outlook. Your lordships will have to give the term denominational character a broader outlook. Because it was suggested, Sampradaya.
Sampradaya followed by the temple, mode of worship, etc. In the case of Ramana Maharshi, which god did he pray to?
That's the interesting part.
Therefore, The followers of Ramana Maharshi indirectly are also followers of that god.
Great. That temple, there is a samadhi. And on the samadhi of Sri Ramana Maharshi, there is a lingam that is placed. All that there was necessary to say is everybody who believed in Ramana Maharshi will definitely constitution a denominational group. They must be given that status.
Who want me to go into all those things?
Grateful.
It's a common belief which constituted. We should leave it to the wisdom of the common believers.
I'm grateful. Because there was a contention.
Collection of people have a common belief. That is sufficient.
sufficient.
They do
Grateful.
not have an organization,
Correct, that's
etc.
Milots, your lordships will see my conclusions, Milots, at page 42. Page 52, Milots, where I have taken the same line, Milots, that it is lordships have to see the commonness and not whether it is distinct or whether they have an exclusive practice, Milots. So long they they satisfy the condition of a commonness, Milots, your lordships. Milots, the other question that was repeatedly posed was whether an entire religion can be a denomination, Milots. My respectful submission, in every fact and circumstances of the case, Milots, in a given fact and circumstance of the case, if the religion itself claims denominational status, I can only think of one good example, Milots, Sikhism. The entire religion through a Gurudwara may claim institutional protection under 26. There you are not saying whether it is one sect of Sikhs or other.
Like they said, a denomination can be bigger one, smaller one, section thereof. For example, Tirupati temple, Balaji temple, everybody will go. Yeah, additionally, they have their own other denomination also. Six thereafter. It's all, see, the flexibility is provided in 25.1. Otherwise, we are making 25.1 is unworkable.
The term Sampradaya was employed.
In the Tirupati temple, everybody goes there. But the temple follows a particular sampradaya.
Vaikanasa.
Whatever it-
Vaikanasa among the Vishishtadvaitas.
That is protected. That is protected.
Grateful. Vaikanasas. That's the denomination, Milots. Milots, if your lordships kindly see, Milots, because Sampradaya from the Hindi text of the constitution was used, Milots, I just looked at the other official versions of the Indian constitution, Milots. The South Indian languages I have looked into. Telugu employs the term, Milots, Shaka, Upashaka. I'm only trying to say, perhaps it's of assistance to your lordships to understand the width of the term denomination. We have inherited an Irish term. It is up to your lordship to Indianize it. We have definitely inherited an Irish term. The Telugu version uses the term Shaka, Upashaka. The Telugu version, the Kannada version uses Dharmika Sampradaya and Vibhaga. The Kannada version employs that term. The Tamil version employs the term Samaya Kilai and then Piraivu for section thereof. Milots, I'm only saying, Milots, we have inherited that Irish term. Please Indianize it, Milots, so that the maximum coverage is there for protection under Article 25 and 26. Milots, I must tell your lordships, Milots, I have prepared a detailed section on mutts and temples, Milots. For paucity of time, I'm not getting into that. But just to indicate my concerns in which temples and mutts have received treatment under Article 26. One, Milots, Hindu temples have always been stripped of denominational status because they say all your temples are Hindu temples, so therefore there is no question of denomination. The temples in this category are Bhurinath, which is Jammu and Kashmir, Milots, Bhurinath, Vaishno Devi, then Guruvayur in Kerala, Kashi Vishwanath in Uttar Pradesh. All of them were not given any protection under Article 26 because the test used was every Hindu goes to these temples. So where is the question of any of these temples getting denominational protection? Guruvayur, Milots, Guruvayur is very important. Guruvayur, your lordships employed the Kashi Vishwanath test and said there's no question of the Guruvayur temple being a denominational temple. But what the court did not note, Milots, was a 5-judge bench of the Kerala High Court. Because I wouldn't have made this argument if it was a single judge bench or a division bench. A 5-judge bench of the Kerala High Court said that the Guruvayur temple is a denominational temple. And it said that the affairs of the temple can be given to a committee by a takeover legislation by the government. But the committee must not comprise of Hindus. It said, the High Court, Milots, I think that was a visionary judgment. It said the committee which is constituted under the Act must consist of believers in the Lord at Guruvayur. The example given is there is an entire section of Hindus which does not believe in Hindu idol worship. If the government fills up the committee with people who are not believers in idol worship, the entire purpose of giving the denomination its rights is lost. So the High Court, with all due respect, employed that and said it isn't sufficient safeguard. The 5 judges of the Kerala High Court said it isn't sufficient safeguard that you say that the committee which will take over the administrative temple will consist only of Hindus. It must consist of people who affirm to that particular god, that particular
It is there in
denomination.
Article 16.5.
Correct.
Article 16.5 is there.
Grateful. No, that is post, Milots. Those are post, those are government posts. But if your lordships are constituted, if the legislature constitutes a committee to oversee the affairs of a temple, Milots, that also the protection must be that it must be people from the same denomination who have a firm faith in that deity or in that practices of that denomination, Milots. Understood. Plus, the Kerala High Court struck down on the Act specific provisions under 25 and 26. But what I wanted to point out to your lordship is that the Supreme Court judgment was given without even adverting to the fact that there was a 5-judge bench decision of the Kerala High Court which conferred denominational status on Guruvayur. Similarly, Milots, Kanyaka Parameshwari temples in Andhra Pradesh, Milots, were not given denominational protection by Supreme Court, despite there have been High Court judgments saying that worshippers of Kanyaka Parameshwari, Milots, are a denomination by themselves. So my respectful submission so far as temples and denominations is concerned, Milots, please give it a larger reading so that all Hindu temples will be covered under the ambit of protection under 26. All religious denominations. Milots, Much, Milots, there is an entire elaborate section, Milots. This court is unfortunately, Milots, I say this term, use the term unfortunate with utmost respect, Milots, and some sense of responsibility. It has virtually brought the institution of a Matadipati to that of a servant. Shirur Mat cautioned against that, but in subsequent judgments, 4 judgments I have cited, Milots, where they say that the appointment of the Matadipati the legislation can state that the appointment of every Matadipati must be affirmed by the executive officer. It places the Matadipati, the executive officer can place a Matadipati under suspension. The executive officer can remove a Matadipati, Milots. My respectful submissions, Milots. Plus, in a Mat, Milots, what is a fulcrum? The fulcrum of the Mat is the sannyasi. The fulcrum of the Mat is the sannyasi. The sannyasi is a person, Milots, who has given up life, Milots, in all practical aspects, Milots. It is as good as civil death.
It is civil death.
It is civil death, Milots. It is civil death, Milots, for all purposes. If your lordships are able to appreciate that point, so far as a Matadipati is concerned, Milots, the role of a sannyasi, Milots, is a matter of great sacrifice. It's a matter of great sacrifice. If your lordships are able to see that perspective, that a Matadipati is a matter of civil death, the sannyasi who performs, on an approach, there are 2 concerns which is generally pervasive in all judgments of this court, Milots. One, Milots, every religious matter is viewed from the perspective of a right. Most people came to this court asking that they be left free to perform their duties and responsibilities under the religion. But unfortunately, Milots, in the anglicized judicial system we have inherited, it can be couched only in the form of a right. So when a Matadipati comes to court, Milots, he is not seeking any personal benefit. He is not coming to court to assert a right. The entire jurisprudence of Shevayats, debited property, etc., Milots, is colored with this perspective. And there are a number of judgments, Justice Mukherjee's judgments, which say, Milots, the English principles of trust, etc., don't fit in the Indian context. Unfortunately, Milots, we are all forced to fit, for the sake of legal remedies and common law, Milots, we are all forced to fit the exercise of duties in the context of rights, Milots. Therefore, Milots, last point, Milots, proportionality, Milots. Would your lordships kindly see 25(2)(a)? There are 2 tests.
Sannyasi is different from Matadipati.
Yes.
Milots,
Every sannyasi is not a Matadipati.
Milots, that I've explained.
Let us not demean a Matadipati to a sannyasi.
Very well. Would your lordships kindly see 25(2)(a), Milots, the test that I have suggested, page 129. Milots, shall I just continue another 5 minutes, Milots? Milots, shall I just continue for another 5 minutes? Great. Milots, page. Milots?
Something which touched touched us personally, that's why we express.
Great.
Nothing against you.
Great.
Yes, please go ahead.
129 minutes, para 17. I've taken some inspiration from Justice Sundaresh's questioning, because Justice Sundaresh's questioning said, could there be a difference in way legislation is tested under 25(2)A and under 25(2)B? So page 129 is my formulation for the test under Article 25(2)A. In the light of the above consideration, the standard of review for assessing regulatory legislation under 25(2)A is the following three-step framework. Firstly, the court must satisfy itself whether the activity in question is secular in character and therefore within the scope of regulation under 25(2)A. Does the activity exist outside of religious practice or religious life? Does the activity fall within the meaning of what is ejusdem generis with economic, political, or financial in Article 25(2)A? Is the activity merely associated with religion and thus not so intimately connected to religious practice so as to qualify as a religious activity? If the answer to 1, 2, 3 are in the affirmative, the activity in question can be regulated as secular activity associated with religious practice. Pertinently, the burden of demonstrating that an activity is secular in nature and therefore amenable to regulation rests on the state. Second, the court may then apply the proportionality test to examine whether the regulation is reasonable restriction on the fundamental right to religious freedom. The court will assess whether the restricting measure has legitimate goal, connection stage, necessity stage. 3, Milots, the court must on an examination beyond the form of regulation satisfy itself that the overall impact of the regulation does not hollow out the religious institution's capacity for administration and management of its affairs. Thus, even where limbs A and B are satisfied, a regulation which assessed in its totality strips the institution of a meaningful sphere of religious autonomy cannot be sustained. The burden of demonstrating that the overall impact remains within permissible limits of regulation rests on the state. This, Milots, I have drawn inspiration from Bennett Coleman. Your Lordship said that a restriction on the number of pages is also a restriction on the freedom of speech itself. So in the guise of regulating secular activity, if you are going to choke the religious activity, notwithstanding the fact that it is a purely secular activity, it will also be struck down. I hope that I've made myself clear, Milots.
To that extent, even Solicitor General also said so.
Yes.
If you have any difference of opinion, two views about it, fall in favor of religious activity.
Chirur Mato
Yes, yes.
said.
Milots, but the Bennett Coleman test is directly relevant there, because they said if a number of pages are curtailed, Milots, indirectly it is curtailing the number of the freedom of speech. Would your Lordship also see my modified test for 25(2)B, Milots? Because this has been troubling your Lordships for quite some time, because I have taken the position that the double proportionality standard does not apply for two reasons. The standard itself does not work. More importantly, Milots, that judgment in ADR, Milots, itself was prefaced in a paragraph where this court held, Milots, again, arbiter. When it said there is a hierarchy of rights, it says 25 is a hierarchy of rights. 25, the subjection clause must be viewed as a hierarchy of rights, and therefore the Constitution provides for a hierarchy of rights. That example is directly given in Association for Democratic Reforms. Complete arbiter, in my respectful submission. Page 131 I've given.
Those are all cases not arising under 25(1). We have to make a distinction.
Kindly see.
You can't just apply like that.
Precisely, Milots. That relevant extract of ADR is at page 131, Milots. It says, for example, page 131, I have quoted it, para 150. For example, Article 25 of the Indian Constitution, which guarantees the freedom of conscience and the profession, practice, and propagation of religion, is subject to public order, morality, health, and other provisions of this part. And this is given as an example of a hierarchy of rights, Milots. My respectful submission, Milots, the integrity of part 3 demands that there be no hierarchy of rights. Milots, now coming to the test, which is at page 135, Milots. At 136, Milots, for lack of time, I'm straight away skipping to the test, Milots, because perhaps, again, this is inspired from the Venkatramana Devaru formulation, para 48, page 136. For the purpose of harmonizing two conflicting rights, whether reflected through a social reform welfare legislation or in the absence of a legislative measure, the following balancing test is applicable. What is the nature and extent of the restriction on an individual's fundamental right caused by the religious practice? In the case of a social reform measure, what is the harm to the individual's fundamental right that is sought to be remedied? This is the first question. 2, does the religious practice in question arise from sincerely conscientiously held religious beliefs of a denomination protected under 26B, read with 25(1). The Parsi case is an example of this, whether they can prove that the exclusion of a married Parsi woman who is married to a stranger is a conscientiously held belief under 26B. C, if the religious practice in question is permitted to continue, can the individual still exercise their fundamental right meaningfully? D, is the proposed measure to restrict or reform the religious practice the best of all feasible alternatives to effect minimal restriction on the denomination's right, but also to enable the individual's right in an equally effective manner? Because if this test, this is partially inspired by Venkatramana Devru, partially inspired by the proportionality principle. This is what I have tried to highlight here. Your lordships will see the table of contents only to see the range of topics that I've attempted to cover in my note. In the last leg of my note, I have attempted to say that perhaps our reading of our constitution must be more indigenous, in the sense that I have attempted to suggest, that Swaraj, how the term Swaraj was employed by Mahatma Gandhi, by Aurobindo, is perhaps something that is nearer to our practices to understand how we read 21, 25, 26, etc. I've made that attempt at page 200.
You said make it Indianization, don't go for Oxford.
Not just that, because Swaraj, according to me, and this is a conception of Justice Mohandas Karamchand Gandhi as well as Sri Aurobindo, is not just external. It has an internal element. It has spiritual freedom. It has dignity. It has self-respect. In none of the judgments of this court on dignity, self-respect, have we ever relied on an Indian doctor.
The first person to use that concept was Lokmanya Tilak.
Tilak was there. Just prior to Tilak, it was Sri Aurobindo's brother who started writing about the concept in his letters to Sri Aurobindo. Bharindra Ghosh, I think. Even on dignity, self-respect, this court could have used Suya Maryada, etc., which has Indian roots, but we have always used elements from abroad. So that is what I've attempted to say in that last portion on Swaraj. I am grateful for the time, for the opportunity.
Thank you, Mr.
Grateful.
We have a little query. Your lordship has wanted an amicus who had given a lecture which has nothing to do with what we argued or what they are. Now, are we to treat him as the inner chamber of judges, which will then advise your lordships? That's the point. Because what he has argued has got nothing to do with what we argue or what they argue. And this creates is a very serious one.
It might have,
This is an unfair comment, my lord.
it might have multiplied our burden, Mr. Dhawan. It might multiply our burden, but you people are relaxed.
My lord, I have a serious objection to this comment, my lord.
Completely unorthodox. It is totally, but not inconsistent with the adversarial system we follow. But not when we have been amicus, we take a position one way or the other. Now the difference is that this is a reference case. Now what they were supposed to do, as we understood it, is given our arguments, responded to them, given their arguments, responded to them in a way that would be understood by your lordships and ourselves. On my part, Lord, I find no relevance whatsoever as part of the computation.
My lord, I am sorry, allow me to say something, my lord, on this. My lord, please allow me to say something.
I don't share that perspective. I don't share that perspective. Lord,
Lord,
if we have anything to say, we can put in a note. I don't share
Absolutely,
that.
my lord. My lord, kindly allow me to say something.
The point is that he has given his own perspective about 25 and 26.
I don't.
And read with other parts of the constitution.
So, Lord,
You have a right to disagree.
I think the amicus is
All of you have,
I
all of you have a right to agree or disagree or partially disagree with the amicus. That's why we are granting exact 2 weeks time. By 29th May, all of you are entitled to submit your revised comprehensive complaint.
My lord, may I say something, my lords? My lord, may I say something?
Perfectly fine.
I'm going to sit down now.
My lord, may I say something?
Thank you. Thank you, Mr.
My lord, may I say something, my lords?
Just a minute.
My lord, kindly allow me to say, my lord, I strongly object to this kind of, my lord, an objection raised against an amicus. My lord, amicus is appointed by your lordships and he is not supposed to satisfy either Mr. Dhawan or other side.
Exactly,
My lord,
that's
he
what
has
we are
given
saying,
his
that we
own.
have given a perspective.
That's why.
My lord, we do not lose our civility.
Anyway, Mr. Singh,
We
I think,
appreciate his stand.
My lord, we do not lose our civility by pointing out that Mr. Dhawan is a party in person in this matter. But, my lord, let it be that way. But I would request Mr. My lord Singh, my lord, Mr. Shivam Singh, not to be cowed down by this. My lord, he is a young man.
On their case, I was trying to sue.
You should not have been wearing your gown, Mr. Dhawan. You should have removed your gown and argued. You are party in person. No counsel is objecting to this.
Like was, to which we cannot understand.
Yeah.
I leave it.
no, it's all right. There is no need of submission. Yes, Mr. Singh, 2 minutes.
My lord, I would request Mr. Singh.
Little more, your lordship.
Lord, I'm only a minute, Mr. Singh. I would request Mr. Singh, he is a young counsel, a brilliant counsel. He need not get cowed down by such observations. But Lord, all of us on both sides are
Nobody is trying to
standing by
cow
him.
down or anything. These are all opinions
No, it's
coming.
all right.
That's all.
Let's move on. Yes.
So it was really unfortunate.
Mr. Singh,
You
I don't know
cannot
how
bully
it
your
will be.
younger colleagues.
I'll take about 5-7 minutes. I won't take more than
Just 5 minutes, please,
Yes.
yeah, because we are also.
I thought I'd take 10, but anyway, your lordships, I'll just
Just,
address the point. I'll just address the point in question. Sir, I'll just give it to you.
Go note.
Sir, what we have done for everybody's benefit is that all the submissions that have been formulated vis-a-vis the 7 questions which have been raised by this honorable court, we've prepared a tabulated grid saying that who has addressed which question in what manner. Your lordships will find that is first done for the review petitioners. Then there are their detailed submissions. After that, we have done
So it's
that.
in a way compilation of both sides that what has been asked.
Absolutely, your
Very good.
Absolutely, your lordship.
Text of submission.
Yes, your lordship. So in that regard, it is this index which is available. It is a grid-like summary. Then there is a detailed summary of all the arguments repeated for the writ petitioners, your lordships. After that, there's just one issue which I wanted to address, that of constitutional morality. Your lordships, day before itself indicated that your lordships have heard this in extenso. So I would not urge your lordships to consider every point of it. All the case law, your lordship's attention has already been invited to it. There are just 2 or 3 paragraphs from my written submissions that I wanted to specifically invite your attention to, your lordships. And those paragraphs which are available, your lordships, I would just urge, and your lordships may mark it. These are para 63 and para 70 to 72. Your lordships, I'll just summarize these in a couple of lines. And your lordships, on the aspect of constitutional morality, the strongest criticism which has come about is to say that this is a relativistic doctrine, it is a value-based doctrine, and it is without any textual foundation. Whereas the strongest defense which has come for this constitutional morality doctrine is that it is an essential check against majoritarianism, and even basic structure is a judicial innovation. So if 13 of your lordships could consider basic structure to be part of the constitutional setup, then there is no reason so as to discard constitutional morality in that framework, your lordships. On most issues which your lordships have been addressed on, probably the strongest position on those aspects has been taken by Mr. Vaidyanathan on all those arguments, and a contrary perspective has been on the other side has been taken by Mrs. Indira Jaising. On this aspect of constitutional morality, the strongest criticism which has been leveled has been that of the learned SG, and the strongest defense which has come about in this regard has been through Mr. Shadan Farasat, where he's talked about the basic structure equivalence, your lordships. In my respectful submission, the idea or the conception which your lordships may deem it to be the appropriate one would lie somewhere in the middle in terms of what has been placed by Mr. Raju Ramachandran, Mr. Ravindra Srivastava, and Mr. Gopal Sankaranarayanan, that there is some value or there is some element of usefulness which is associated with retaining it as a doctrine, and at the same time not using it as an overarching basis to invalidate legislations.
And to make good this argument, your lordships, I'll just para 70, 71 and 72 of my written submissions are a complete answer to that. I won't go beyond that. Your lordship,
Para 70 and 71.
70, 71 and 72, your lords. Page 142 and 141 to 143. Your lordships, and just to contextualize it and make it in the simplest possible form, I've used an analogy of sports, particularly cricket, so as to ensure that your lordships are able to grasp it in the correct form. Your lordships, when it comes to legislation and invalidation of legislations, there are only three remedies or three areas on which it can be invalidated. The first being Part 3 violation, the second being 7th schedule or legislative competence violation, and the third being any other constitutional provision, more often than not, that is sometimes traced to Article 265. Now, your lordships, my submission is that please employ constitutional morality to understand the depth of the violation of a right and do not use it as a standalone or a supplementary ground to strike down the law. Please employ constitutional morality as a doctrine to reflect on why a law has violated a constitutional provision. And let me just analogize this to cricket, your lordships. Now, in cricket, what we see is that, and the idea being the spirit of cricket, or generally sportsman spirit. Your lordship, there are recognized modes of dismissal as per the laws of cricket. You can be declared out for LBW, bowled, caught behind, etc., etc. You cannot be declared out.
In sports law.
I know, I've written the foreword for it.
Expert on sports.
I've written the foreword for it.
Yes, he's a chip of the old block. He reminded me exactly of his grandfather, Mr. D.P. Singh. I had the great privilege of knowing him.
Grateful, your lordships. Grateful. Now, your lordships, on this aspect, wherein the spirit of cricket, which is relevant to understand, you can be declared out in the recognized forms of dismissal. You cannot be declared out because you are violating sportsman spirit. You can use spirit of cricket to understand that what is, say, stumping or what is, say, run out. Some person is deriving a advantage and the fielding team is alert, and therefore they're able to run this person out. So please use the spirit of cricket or constitutional morality to reflect on what is the reason behind such a provision being there, but do not use it as a standalone basis so as to invalidate a legislation, because then that creates a problem. And this, your lordships, in fact, in this regard, this was an argument, in fact, raised by Dr. Dhawan in the morning. In this context, that when we are seeing as to what is constitutional morality, we've traveled a long line of decisions. We've dealt with all those cases, whether it's the Narula case, GNCT Delhi, etc., etc. So on all these aspects, what is relevant is that please do not have a freestanding power available so as to annul a legislation, because number one, a presumption of constitutionality will always attach with a constitutional piece of legislation. That's number one. Number two, your lordships, is that constitutional morality is extremely abstract in its forms because it is nebulous and it can be varied from person to person. And just as I offered in my analogy prior, that the spirit of cricket can be understood by different umpires in different ways, your lordships. Constitutional morality can be understood by the most learned of judges in different ways, and that may not necessarily align with the aspect on how a legislation should be struck down or invalidated, your lordships. And having said that, your lordships, and since I'm the last person to address your lordships, please accept my deep sense of gratitude for all of your lordships who have heard this matter across so many days, your lordships. I would also like to place my appreciation for my entire team who has been assisting in this matter, especially my clerk, your lordships, who has done a lot of the heavy lifting in terms of the preparation, and for the guidance and support of all the senior members of the bar, as well as the younger members of the bar and the nodal councils who have probably worked tirelessly and who have taken the lead in ensuring that your lordships receive the best possible assistance. I'll leave it to the senior members of the bar to address.
Lord, we join the learned amicus My Lord, for the extraordinary
Really, my
hearing,
lord,
my
a
Lord.
privilege and a
An
pleasure
privilege.
and a learning experience, my lord, to address this honorable.
Same thing is for us also.
Can you,
We also learned a lot.
none of us, my lord, are leaving
Only
the
one
court
submission.
with any dissatisfaction that we were.
This
My lord,
reference.
only, my lord,
Thank you very much to all of you, the kind of cooperation and the quality assistance that has been provided to all
It's
of
an
you.
intellectual treat.
please, my lord.
Sometimes we kept on asking so many irrelevant questions completely out of context.
Please,
But the way the patience and the response you give, that was also very remarkable.
please, my lord, only one line submission. Only one line submission. My lord, only one line
Judgment
submission.
reserved. The part stroke interveners shall be permitted to submit comprehensive compilation of their written submissions, subject to the condition that earlier written submissions or supplementary submissions shall stand withdrawn.
Solicitor,
Also to file the. Asking some question.
You're right.
No need, no.
No, supplementary you can give, comprehensive you want to give, because we don't want that comprehensive.
Whatever you see,
Don't say shall, maybe withdrawn, subject to
Mr. Giri,
the earlier.
we come for your arguments were commenced. Today is the 18th day. This reference is an offshoot of Shabrimala, the 18 steps.
Yeah, yes. That's a.
Dumb.
There cannot be a better person than my brother. There cannot be a better person than my brother to say this, because he himself is a Guru Swami.
I hope we don't have to
Thank
withdraw
you
the
very much,
submission.
thank you all of you.
Obliged to allow.
Saying that you can submit a comprehensive written submission, because we don't want that we start right from the original submission, then supplementary, then another
And
comprehensive.
duplications.
We don't need to fast please.
Yes, yes.
That's your sweet will. Otherwise, whatever you have already filed, we will consider that. Yes, yes. Thank you very much. Thank you all of you.
Withdrawal of the
Yes, sir, you are already there.
submissions can't be
Comprehensive, they
withdrawn.
can incorporate everything.
It is withdrawal of
It can
earlier
be-
version.
Right.